Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education commentary, and today will be the day I earn that subscription. For today's stream, we are discussing Amber Heard's latest pronouncement upon the court. She has moved in the trial court to have the jury verdict set aside. I am sure the judge is just super thrilled, because the judge has basically announced that they are done. And so I'm imagining the response to this may very well be one sentence of go away and go to appeal if you can afford it, because nothing else is going to happen. But we're going to read this motion for what it's worth, which is not much, including the conspiracy theories about fictitious jurors and people just randomly appearing on the jury from nowhere. Who knows where these jurors are from? Could be from anywhere, we've decided, apparently. So we're going to read this, and we're going to discuss this legal amount of stupid. Let's get started with this. I mean, we might as well, because we can't appeal, because we don't have the money. So we might as well try to get the judge to reconsider, but, no. The jury has sat and rendered their verdict. I know. I watched it happen. Yeah. Okay. Defendant and counterplaintiff Amber Heard respectfully moves this court, and again, we are in the trial court, so some people have said, oh, she filed her appeal. This is not her appeal. We are still in the trial court. We are still trying to get the trial court to do our bidding. Good freaking luck. Respectfully move this court to set aside the jury verdicts on all three counts of the plaintiff and counter-defendant. The complaint dismiss the complaint, alternatively order a new trial, investigate potential improper jury service. Oh yes, people just randomly serving on juries. That's definitely a thing that's definitely happening for sure. Let me tell you what. In support, Ms. Heard relies upon the record, including objections and arguments during the trial, and motions to eliminate, motions to strike, and arguments the following. Exciting. From the beginning, in the before time, in the long ago, Mr. Depp set out to try this case as a domestic relations dispute he wished to have tried, rather than settled in 2016. I don't know, I thought it was for the defamation for the articles you wrote. Mr. Depp's counsel argued throughout the trial that the issue before the jury began 6 years ago. I mean, that's sort of where the root of some of this takes place, but then again, the article revivified a lot of that. It's kind of the point. When Ms. Heard obtained a domestic violence temporary restraining order against Mr. Depp and his legal team told the jury they were seeking to restore Mr. Depp's reputation and legacy for his children. This was the first time Mr. Depp has been able to tell a story since Ms. Heard obtained the domestic restraining order in 2016. The claims in this case were far different than the case Mr. Depp tried to the jury. Okay. Mr. Depp's claims arose from an op-ed published in the Washington Post on December the 18th of 2018, 2.5 years later. Mr. Depp alleged that three statements, one the title authored by the Washington Post. Technically speaking, we never determined for sure who authored the title, but sure, formed the basis of the defamation claims. To avoid explaining to the jury the UK final judgment, finding Mr. Depp to have committed 12 acts of violence. I mean, I don't know how I have to explain this to everyone, but let's just go through the basics. It is a different court. And more to the point, it's in a completely foreign jurisdiction. You see, there's this nice clause of the Constitution. That says every state has to give full faith and credit to the judgments of other states. It's called, conveniently, the Full Faith and Credit Clause. It is a clause of the Constitution that says, hey, if there's a decision from Maine, or a decision from Florida, or a decision from California, or a decision from Utah, right? The court in Virginia is required, obligated, compelled to give full faith and credit to that judgment. Because you see, we're a bunch of states united, and so we have to give full faith and credit to each other's judgments. You know what the UK is not? A state of the United States. So there's that. There's very distinctly that. They are a foreign court in a foreign land. In fact, as tomorrow comes to mind, July 4th comes tomorrow, I seem to remember July 4th has some sort of significance. vis-a-vis the United Kingdom, some sort of thing where we don't have to give full faith and credit to their judgment. I seem to remember some sort of tie between these two concepts. It could just be me. Okay, anyways. All right, so to avoid explaining to the UK the judgment, which is a different judgment by a different court involving different parties, incidentally, Mr. Depp represented the court. He would limit his damages claims to the period of December 18th of 2018 through December 2nd, 2020, the date of the UK judgment. Yet Mr. Depp made no such efforts to point at any point of the trial that he limited his damages. Well, he doesn't really have to explicitly. See, he can just lay out damages that occurred at various points. And the jury, which is the trier of fact, the jury gets to determine what happened when. See, he gets to say, oh, here's some things that happened in the past, and here's some things that happen now, and here's some things that might happen in the future, because damages can speak to the future losses, future earnings, right? Things that will occur or things that might occur. And how do you determine all that? Well, you get a jury and you say, okay, jury, what do you think? What do you think are the damages between these two dates? And the jury says, we think this is the number. Fantastic. Great. All right. Yet Mr. Depp made no such efforts. Well, the jury figured it out. Instead, even throughout the closing, Mr. Depp urged the jury to restore his reputation legacy to his children, a result of Miss Heard's accusing Mr. Depp in the violence of the restraining order. Yes, but you see, one of the things that happened in the article was she renewed all that. She brought that all back up. She didn't leave the past in the past. That's part and parcel of the problem. She brought it all back, bringing it back again. It's the new hotness all over again. The jury's verdict was obviously influenced by Mr. Depp's pleas in the face of the court preclusion, as opposed to your pleas in your own closing that said they should consider the larger issues in the Me Too. Preclusion from Miss Heard from introducing evidence that Mr. Depp had already, in fact, been adjudicated in the court of his choosing to commit not just one act of domestic abuse, all it was needed for this case for direct verdict, but 12 acts of domestic violence, including SV. Well, not for nothing, but it's up to the jury to determine what the words in the op-ed mean. And it is at least hypothetically possible in some combination of universes, the jury could believe that individual incidences did occur, but not arise to the level of domestic abuse or sexual violence. Because what those terms mean is a question of fact for the jury. See, if we were in a domestic violence case, right? If we were in a domestic violence case, these terms would be defined to the jury. They would be told what domestic abuse would be, and they would be told what sexual violence would mean. But we're not in that context. We're in the context of a defamation case. So one of the questions the jury has to decide is, what do these terms mean? So it's at least hypothetically possible the jury could believe some particular incident of something that might resemble violence occurred, but not believe it arises to domestic violence. Because those are two, at least hypothetically, different questions. And it's one of the questions is, what does this mean in this context to a person of ordinary reading? What does it mean in this article? What does domestic abuse mean to a person reading this article? What does sexual violence mean to a person reading this article? Does it mean, for example, he grabbed me by the arm one time? It might mean that. It might not mean that. Well, that's one of the things the jury has to determine is, what does it mean? Because what are the facts being conveyed by the article to the person reading it is a question of fact for the jury. Now, of course, they could believe none of these things occurred. And also, as I mentioned before, the UK judgment is in a foreign court involving different entities, and we don't have to give full faith and credit to them. So, ignore them. That'll be fine too. Okay. The exclusion of the UK judgment, which makes total logical sense because it's different parties. See, if it were the same parties, we could still have a collateral estoppel argument because it would be the same parties, right? The same parties have adjudicated their dispute elsewhere. Now, we could, of course, continue to try to ignore that because, as I mentioned, the UK is not entitled to full faith and credit in the United States because something happened, something 1776. So even if that issue, we could still get past it anyway, right? If it were a court of Maine that issued a judgment, we'd be in a whole different universe. But we're not in a court of Maine. We're in the court of the UK. It's almost like it's a different country. So yeah, the fact that and also that only works if it's the same parties, because then you have collateral estoppel. The same parties in a collateral, that is a sideways proceeding, like collateral proceeding, right, are estopped, precluded from raising the same arguments against. Collateral estoppel. But it's different parties, because Amber Heard isn't a party to the UK. It was between Johnny Depp and the Sun. So collateral estoppel also has that problem too. Okie dokie. The exclusion of the UK judgment because different country, different parties, coupled with Johnny Depp's continuous urging for the jury to go back 6 years and exonerate him or restore his reputation, because the article goes back that far. 2 years ago, blah, blah, okay, yeah. Resulted in an indefensible $10 million compensatory damage verdict and $5 million in punitive. The verdict is excessive as a matter of law in light of evidence and law, and it should be set aside. No. Further evidence and confusion resulting from Mr. Depp's efforts to relitigate the 2016 domestic relations matter without the truth of the UK judgment. It is a different court in a different country. The jury's dueling verdicts are inconsistent and irreconcilable. Now, what's interesting is that inconsistent verdicts. I don't know that much about Virginia specific law, despite being Virginia licensed, because my field of law was federal. But inconsistent verdicts are legal in the federal system, at least. You can have verdicts that are inconsistent. You can even have them inconsistent in a criminal case. I don't know the degree to which Virginia allows for inconsistent verdicts, but you can do that. You can have inconsistent verdicts, because the thing is, you don't know which verdict is inconsistent with which. And you don't know where the jury was trying to maybe make or break or something. So like a classic example, just to illustrate the point. And the United States Supreme Court has had to confront this exact scenario, which is why I know that you can have inconsistent verdicts, right? So you could have a criminal case, felony murder, right? Felony murder is where you have an underlying felony and a death occurs in the course of the felony, right? Underlying felony, say for example, robbery. We'll take an easy one. Robbery of a convenience store, right? It's a robbery of a convenience store. Someone dies in the course of that robbery. That's felony murder. Okay, so you go to a jury and you say, okay, jury, what do you think? Do you think the felony murder? And it has happened, and the United States Supreme Court has had to rule on this, where the jury has said, you know what? We do not find the underlying felony, but we do find the felony murder. And everyone goes, what? Because you can't have the felony murder without the underlying felony. It's the equivalent of saying, the jury saying, we find not guilty on the robbery, but we find guilty on the we find guilty of the death in furtherance of the robbery. Right? We do not find the robbery, but we find the death in furtherance of the robbery. This is what we talk about in inconsistent verdict. Now, the U.S. Supreme Court has had to consider this issue and had to consider whether or not this is a problem. And the federal answer is nope. It's not. Why? Because we don't know where the jury is trying to create a break or not. We don't know which verdict is inconsistent with which, right? Maybe the jury was trying to give them a break. Maybe the jury was being merciful that day and just said, you know, we don't find the underlying felony, but we do find the death in furtherance of the felony. And then the Supreme Court has said, yeah, it's totally fine. Totally fine, not a problem. You can have your inconsistent verdicts. You can have your cake and eat it too. Totally not a problem. So, like, even if they were inconsistent verdicts, it's not necessarily an issue, because the law does allow for that, at least on the federal level. Of course, Virginia would be entitled to its own separate judgment, but I know more about the federal system because that was my field of practice. Great, moving on. The finding of defamation against Ms. Heard with $2 million award is inconsistent with finding of Johnny Depp against $15 million. First of all, no, it's not, because it's totally possible to reconcile the two statements logically. And second of all, even if it's not, the U.S. Supreme Court wouldn't care. In the face of these inconsistent verdicts, the judgment should be set aside and a new trial ordered. Okay. At trial, Mr. Depp proceeds solely on defamation by implication theory, abandoning any claims that Ms. Heard's statements were actually false. But where, as here, the statements are true on their face, which Mr. Depp never challenged on their face, the plaintiff is a public figure, which Mr. Depp has conceded he is. He's a general purpose public figure. It's worse than that. Right? Normally, we only talk about a limited purpose public figure, but Mr. Depp falls into the category of general purpose. he's famous enough to meet the criteria. So he's a public person for all purposes. Subject matter of the op-ed is on matters of public concern, debatable but sure, which the court early determined as a matter of law. The First Amendment prohibits claim by implication. Does it, though? Not to any of my knowledge. I'm not aware of any First Amendment case law on point, but maybe you'll educate me. While this appears to be a case of first impression in Virginia, a case of first impression is another fancy way of saying there's no precedent. That's what a case of first impression means. A case of first impression says this is without precedent. So we want to say, yes, the First Amendment prohibits this, and also there is no precedent. Okay, that's fun. As long as we're talking about mutually inconsistent ideas. This is not allowed by the First Amendment. Also, no court has ever considered this before. Super duper. While this case appears to be a case of first impression in Virginia, dicta in our courts, oh joy, dicta is the non-binding parts of opinions, and holdings in other courts in similar circumstances warrant applying this doctrine to our case, setting aside the judgment and dismissing the complaint. Hey, Court of Virginia, since this is new to you, would you like to, just adopt some other decision from some other court? Even assuming Virginia wanted to go that way, somehow I don't think this is the case for you. Right? Maybe some other time. Not this thing. This is one of the nice things about appellate courts is or not, depending on your point of view. But there's no decision requiring it. So the Court of Appeals can just be like, nah. And the Supreme Court of Virginia could be like, well, we could, but we're not going to because we can't be bothered to care. So whether or not that's a good thing or not, well, it's a thing. So let's continue on. Mr. Depp never challenged the fact that Ms. Heard did not write the title of the op-ed, one of the 3 defamatory statements comprising the defamatory claim. Instead, Mr. Depp contended Mr. Heard's tweet of a link to the article following day constituted actual republication. It sure does when the tweet begins with, "Today I published in the Washington Post, blah, blah, blah." Yeah, that's republication. It's the most republication there's ever been in the history of time. It's the most republication there's ever been. In addition to establishing dangerous precedent, suggesting anyone tweeting or retweeting an article or a link can independently be liable for the content, that is not the holding. That is not the holding. If it were a mere retweet without more, we've got case law on that. A mere retweet without more is not enough. And although there's no case law, to the best of my knowledge, specifically on point, at least as far as I would be happy to say, a tweet as well. So if all you did was tweet the link, I would say that's not republication. It's definitely not in the case of a retweet. There's no case law specifically on point on the case of a tweet I'm aware of, but a link by itself without more, I'll be happy to say that is not a republication. But unfortunately, Amber Heard did more, a lot more, including by saying specifically, "Today I publish in the Washington Post, blah, blah, blah." If that's not republication, I don't know what is. It isn't like she retweeted it or tweeted it by saying lol, or tweeted by saying check this out, or tweeted by saying this is funny, or tweeted by saying some other sort of banal comment. Her comment was about the most republication you could possibly dream up. If you're a lawyer trying to dream up what your ideal republication case would look like, what is your fantasy? What is your fantasy republication? It would have to be something close to, "Today I publish in the Washington Post, blah, blah, blah." That's about as most republication as you could dream up in your dreams. So yeah, that's gonna work. Okay. Because nothing in Ms. Heard's tweet constitutes legally enforceable republication, get wrecked, is all I have to say about that. This is the most republication that's ever been republished. All right? I just to make sure that everyone's keeping along, right? Publication is when you write it in the first place. That's the publication. So the publication in this case is the op-ed, right? The op-ed in the Washington Post, that is the publication. Republication is where you say, yeah, I'm also adopting that. Now, if it is just the link by itself in a retweet, not enough. At least for my money, if it's just the link by itself in a tweet, not enough, right? Not enough to constitute republication. If it's just the link but maybe with some other stuff that's sort of banal and meaningless, Maybe that's not enough, right? We don't have case law specifically on point, but the logic flows, right? If we're going to say the link by itself is not enough in a retweet, and we're going to say by extension in a tweet it's not enough, the link by itself, then we can also say the next logical step of, okay, even if you have some sort of banal statements like check this out, or this is interesting, or lol, get wrecked, or whatever, right? If you just have some banal sort of statements, maybe that's not enough too. You know what is enough? You know what is enough? When you write today, I published in the Washington Post this article. It was me. I wrote it. I did the thing. I am responsible. That's about as republication-y as republication can get. All right, fine. Because nothing constitutes republication, it definitely does. Since the award does not separate the three separate statements, no. In the event that does not dismiss all three counts, the judgment should be set aside, a new trial awarded on the remaining damages. No. Absolutely not. All you needed was one. Not even a little bit. Not even a little bit. For the jury to find her demonstrate actual malice, Mr. Depp was required to establish at the time the op-ed was published, Miss Heard did not believe she had been abused or that she had doubts about whether she'd been abused. Is it? You're saying it's subjective? I hope you have some case law for that. But instead, Miss Heard, and also, even if it is, you know who you could ask? The jury. But Mr. Depp presented no evidence that Mr. Heard did not believe she is abused. The jury can form that conclusion. They obviously heard from Miss Heard. Instead, the evidence overwhelmingly supports Miss Heard believes she was the victim at the hands of Mr. Depp. Does it, though? Does it? Does the evidence overwhelmingly support that belief? I don't know, man. I'm not so sure about that one. Therefore, Mr. Depp did not meet the legal requirements for actual malice. Next, Mr. Depp improperly relies on time-barred and judicially privileged statements as the basis for his defamation by innuendo claims. Although actual innuendo must be drawn from the four corners of the document, in this case, it could only be drawn from reference in an article to Miss Heard obtaining the TRO. Yes, because she said 2 years ago. What happened 2 years ago? Oh, that's right. This warrant set aside the verdict. Finally, on the information in the jury panel appears to be inconsistent with the identity and demographics of one of the jurors. Yes, fictitious jurors coming out of the pipeline. This is a first. I don't think I've ever seen this ever in any case. This might truly be the first time I've ever read this. So this is hilarious for me. Juror number 15 was apparently born in 1970, not 1945, as reported to and relied upon the parties, including Miss Heard, in selecting the jury panel. Given the requirements for verification, it appears that the identity of the juror was not verified. It is unclear if juror number 15 was ever in fact summoned for jury duty or qualified to serve. This warrants investigation. Depending on the result, this may set aside the jury. Yeah, no, that's not happening. This is not happening. This is just stupid. This is dumb. The judge has already said that she's done. I think it is more likely than not the judge's decision on this is going to be like 2 sentences tops. Be like, no, go to appeal. I think it's probably the answer to this thing. I don't think the judge is particularly inclined to write a lot more at this point. No, go to appeal sounds about right. All right. Let's read this thing. The jury returned a verdict in the amount of $10 million in compensation and $5 million in punitive. The punitive damages was reduced to $350,000 pursuant to law. These damages are unsupportable by evidence and cannot be upheld as a matter of law. Really? Okay. Under Virginia code, where damages awarded are too small or too excessive, courts have authority to order a new trial on all issues solely on the issue of damages or remittitur. Which remittitur is where the judge just says nah and just changes the amount. That's one of the things judges can do, right? So if the jury says, how about $3 billion? Remittitur is where the judge says, nah, how about it inserts a different number, right? So the judge can say, nah, let's have a trial over, or nah, let's have a jury just on the issue of damages again, or nah, I'm just going to change the number. That's the things the judge can do, but they have to do it within the bounds of the law. Like when it's too small or too excessive, where it doesn't make any logical sense. That's when the judge can do those things. They can't just do it for the hell of it. Okay. Whereas a general rule, a trial court should not disturb a jury award that's been fairly rendered and based upon competent evidence, and you can just kind of stop reading right there. Right? While as a general rule, a trial court should not disturb a jury award that's been fairly rendered and based upon competent evidence. And we all be like, okay, well, good night, folks. It's been fun, right? Courts have a duty to correct a verdict that appears plainly unfair or would have resulted in miscarriage of justice. Circumstances which compel setting aside a jury verdict include a damages award that is so excessive it shocks the conscience of the court, creates the impression the jury was influenced by passion, corruption, or prejudice. The jury has misconceived or misunderstood the facts or the law, or the award is so out of proportion to injuries suffered as suggests it's not the product of fair and impartial decision. Setting aside the verdict as excessive under these conditions is an exercise of inherent discretion of a court. Discretion also being a key word in those sentences. It's not even mandatory. It's not even mandatory. It's inherent discretion. Discretion. It's not even required. So first of all, the judge has to conclude the jury was batshit crazy, and then has to decide they care about being batshit crazy. Then you have to get into an abuse of discretion analysis, right? Because if you want to say, oh, the court has discretion, and the court's going to be like, nah, we're not going to do that, then you have to say, okay, now the judge is batshit crazy. Right? So not only is the jury batshit crazy for issuing this award, but the judge is batshit crazy for not issuing a remittitur or ordering a new damages or something. It is so far outside the realm of all sanity, it comprises an abuse of discretion. Does that sound like the kind of thing that's going to happen? The Court of Appeals is going to be like, yes, this award is so far outside all that's conscionable, we can't believe it. And even more to the point, we can't even believe the judge didn't see it that way. That judge must have been wackadoo. Does that seem like the kind of thing the Court of Appeals is going to do? It doesn't seem that way to me. Let's read some more. Here, the jury's determination of $10 million is excessive as a matter of law, as there's no evidence to support the verdict. Really? No evidence? I don't know, man. Seemed like there was some evidence to me. I seem to remember hearing the 6 weeks of evidence, to be quite honest. Mr. Depp was limited to damages from December the 18th, 2018 through November the 2nd of 2020, about 2 years. The court, during opening statements, prohibited Ms. Heard from telling the jury about the Sun article, which was published in April 2018, because it's outside the damages award. Oh my God, you want to have it both ways. All right. Mr. Depp is limited to damages from December the 18th, 2018 through November the 2nd. Also, they're not being allowed to be told about the Sun article in April 2018. Hey, April 2018, I'm confused. April 2018, I'm confused. Is April 2018 between the dates of December 2018 and November 2020 or not? I'm so confused. I can't remember. Oh, wait, no, it's like it's outside those dates. Oh, maybe that's why the jury is not being told about it, because it's outside the dates. Oh, and also because it's a foreign judgment in a foreign court, and also because we don't have full faith and credit, and also because there's no collateral estoppel because it's different parties. I mean, just pick your reasons. There's just so many reasons we're not telling the jury about it. Pick one. Okay, so could be some of those reasons. Nearly 8 months before the op-ed, because it's outside the date window, the jury in July 2020, during the limit period Depp was able to claim damages. The trial of July 2020. The trial of July 2020. I don't know, foreign court, res judicata, but not because it's a foreign court, full faith and credit, collateral estoppel, different parties. And it doesn't quite work. The complaint filed by Mr. Depp in June 2018 alleging irreparable damages to his reputation, the 3-year trial on the libel claims, ensuing publicity surrounding the trial on the UK judgment, which concerns different parties, a different publication, a different statement, which is defamatory or not on its own terms. I mean, at least hypothetically, it is totally possible, at least in some universe, that the Sun article is not defamatory and the Washington Post is defamatory, or vice versa, or they're both not defamatory, or they're both defamatory, because they're two different publications, right? There are two different publications, published in two different places at two different times by two different entities. It is therefore possible from first principles that they could both be defamatory, neither be defamatory, the one not the other not the one. These are some of the many possibilities that emerge. All right, great. Or the UK judgment, a 129-page, 585-page document issued November the 2nd, 2020. Not relevant, no full faith and credit. Res judicata doesn't apply because res judicata, collateral estoppel doesn't apply because different parties. After many of Mr. Depp's witnesses had testified, the court then allowed Ms. Heard to raise, but not amend the evidence, the Sun article, the fact of the trial, and publicity, but still not the UK judgment because it's not relevant. Oh my God. In an effort to prevent the UK judgment from coming into evidence, it's not evidence. It can't possibly be evidence. It literally can't possibly be evidence. It is first of all, it's an opinion, so it's not evidence of any kind. It's a judicial opinion. It's not evidence. It's a conclusion, not evidence. Second of all, it's not relevant to what happened in the Washington Post. The judgment, at best, speaks to what did or did not happen in an article in the Sun. It does not speak to what did or did not happen in an article in the Washington Post. It can't possibly speak to that. Lame. So lame. Notwithstanding the representation, he would not claim any damages other than this period. Mr. Depp made no attempt to limit his damages. And the counsel in closing made clear they were seeking damages from May 27, 2016, the date they sought and obtained the TRO through the president. No, they weren't doing that. They were simply pointing out the article by its own terms, referenced back to that date. Because it did. This was highly prejudicial to Ms. Heard. Necessarily created confusion for the jury, and the resulting $10 million in compensation and $5 million in punitive reflects the jury's belief it was restoring his representation based on the initial filing in 2016 as the counsel requested in opening and closing. This alone justifies setting aside. No, not really, because you're the one that wrote 2 years ago, I became a spokesman for domestic violence. Oh, what happened 2 years ago? Oh, that's right. The TRO is what happened 2 years ago. You're the one bringing that into it, right? You are reinvigorating those claims. Right? The damages only exist from this date to this date. Unfortunately for you, one of the things that occurred between those dates is you mentioning things that happened 2 years ago. So now you are bringing to light all that stuff. So you're not suing for it happening the first time around. You're suing for it happening again. You have republished it, a concept you should be becoming increasingly familiar with. But no, apparently not so much for some reason. All right. Mr. Depp presented no evidence of any pecuniary damages suffered in a limited period. There was no evidence of any projects lost or commercial opportunities because of the op-ed. Really? Really? I mean, baseline principles, the jury is entitled to all reasonable inferences from the evidence presented. There was quite a lot of evidence presented, quite a lot of it referring to particular dates and particular awards and particular things that didn't happen, and from his agents and from his accountants and from all kinds of stuff. Being like, yeah, and so the op-ed happened. The op-ed happened, and here's some money he was making, and then here's some money that was not making. And a jury could conclude, maybe the money he was not making was because of the op-ed. Do we need something directly tying it? No, we do not. No, we do not, because the jury is entitled to all reasonable inferences, right? The jury can say, hey, guess what? Johnny Depp was making a whole bunch of money on a whole bunch of films. Then the op-ed happened. Then not so much with a whole bunch of money and a whole bunch of films. And the jury can go, aha, maybe it's because of the article that happened. It's like, oh, there's no direct evidence. That's what we call an inference. It's an inference, which a jury is entitled to make based on the evidence presented. Yeah. Moreover, Mr. Depp cannot establish any reputational damages from the op-ed because the evidence was that Mr. Depp lost nothing less than everything When Miss Heard obtained the TRO against him, that's not what he said. And then there were 2 years of just constant worldwide talk about Mr. Depp being this wife beater before the op-ed was even published, including the Sun's wife beater article. In addition, any reputational damages after the op-ed, which never mentioned Mr. Depp by name, would have been non-existent or the best nominal compared to the Sun article, the lawsuit brought by Mr. Depp, the publicity over Depp, and the subsequent trial. This doesn't make any sense at all. This doesn't even make any sense at all. The Sun was to a different audience. The reputational harm that Mr. Depp suffered from the Sun article is completely different, because the Sun is a newspaper that exists in the UK. That isn't to say that no one in the US reads the Sun, but it's not exactly a household name in the US. It is quite possible a substantial percentage of people had never heard of this article in the Sun in the US. Not to mention even the UK, where not everyone reads the Sun either, because it's considered a bit of a trash newspaper. But it's even less true that people in the US would have heard of it. So the reputational harm from the Sun, is at least not immediately obvious. It's at least not immediately obvious that the Sun caused reputational harm in the US, because people in the US don't read the Sun. It's a lot more likely that any harm befell him because of the Washington Post, because people in the US read the Washington Post more than the Sun. So it's completely possible to think all the damage, you don't have to think this, I'm just saying it's possible. It's possible to think all the damage that happened because of the Sun was confined to the UK. And it's a whole new world of damages because of the Washington Post. Different audiences, different paper, different people reading it, different damages. It's not that hard. Excuse me one second. Moreover, the exclusion of the UK judgment necessarily prevents a reasonable or competent assessment of any damages, including reputational damages as well as the credibility of inserting damages. No, they don't. Completely different markets, completely different audiences, completely different publications, completely different people reading it, completely different harms, completely different damages. It is completely possible to logically segregate the damages. You don't have to, but you can. There's no way a jury can determine any level of damages from Mr. Depp from the op-ed without taking consideration all potential alternative causes damages, much less as such an overriding one brought by Mr. Depp's election to file a libel suit in the form of his choosing, claiming irreparable damages to his reputation from the Sun article. Sure, he suffered damages. The question is, how much did he suffer from this article? That is the question, and the evidence presented was as to that effect. And we went back 2 years in time relative to the article because Miss Heard is the one that brought it up. She's the one that brought up the 2 years ago. Well, now we're going back 2 years in time because you're the one bringing it up. So now we're going back in time, bringing that up and retrenching all those issues. It's like, you made some choices, so deal with it. There can be no damages reasonably tied to the op-ed, much less 10 million. It's excessive in matters of the law. No, it's not even close to excessive as a matter of law. It's not even close to excessive as a matter of law. Mr. Depp is a very famous actor. We saw in his trial that he is awarded many, many millions of dollars for his parts, as you would expect. His name is worth something. Is it reasonable to think that he suffered $10 million worth of damages in that 2-year period because of this article, which was published to a different audience at a different time in the height of the Me Too movement, and circulated around the US, where more people would read it, had a greater impact, and he suffered damages? Is it reasonable to think that he suffered $10 million worth of damages? I'm going to go with yes. And we are not making this assessment in the dark. We're making the assessment based on what was presented at trial. There's more than enough to draw these conclusions. There's no evidence of pecuniary damages from the op-ed, isn't there? Taking the evidence in the light most favorable to Mr. Depp, there's no evidence upon which the jury could reasonably rely to determine Mr. Depp suffered any pecuniary loss from the op-ed. Well, that just sounds like a whole bunch of bullshit. While Mr. Depp asserted he lost Pirate 6 because of the op-ed, there's no evidence upon which the jury can reach such a conclusion. Mr. Depp did not have a contract for Pirate 6. There was media coverage that Mr. Depp would not be in Pirates 6 as of October the 25th, 2018, 2 months before op-ed. Mr. Depp agent testified it was very likely he would not be in Pirates 6 as of fall 2018. And Mr. Depp testified he would not have agreed to pay the role for $300 million and a million alpacas. I wonder why. All these things are conflating different periods of time, it's also worth noting. They're all conflating different periods of time in which different things happened. So, like, yeah, I mean, he testified as to the $300 million and a million alpacas. Now, because some things kind of happened in the interim, feeling a little bit salty at Disney. I wonder why he might be feeling a little bit salty at Disney, you know, since they kind of stabbed him in the back after bringing them, you know, a couple $1 billion worth of movie property. Might be feeling a little bit of betrayal. Just some, you know, some random thoughts of betrayal, you know, just... Could be all those things, yeah. Moreover, Disney corporate represented that Pirate 6 is still a project that's possibly in development in the studio. So, incidentally, if it's still in development, that means that Disney could theoretically change its mind about Johnny Depp being in Pirate 6 because it's still in development. And that Disney would not entertain paying Mr. Depp $300 million and provide him with a million alpacas. I don't know. Disney might change its mind in the future. You know? And Depp could change his mind in the future, right? These are not like things that are set in stone. And Disney's representative further testified she did not know if Pirate 6 would ever be made. Yeah, but the jury's allowed to project into the future. The jury's allowed to consider all this stuff and believe or disbelieve these witnesses in whole or part. One of the things juries get to do is they get to assess the credibility of witnesses and also the degree to which they are telling the truth or not, in whole, in part, in fraction, or elements thereto. This includes, incidentally, disbelieving Depp about whether or not he would, in fact, take Pirate 6. So one of the things the jury could theoretically do, if they were so inclined, they could be like, yes, Johnny Depp was lying. He would totally do the movie, and he would totally do it for $300 million, and as a result, we think he lost out on some money. Because he would have totally done it. He was lying about that part. So we think he should get the money for the movie that they won't let him do. You know, he was just being too humble. Would be a way to parse that, by the way, without calling him a liar. He was just being too humble. You know, he would do it. We don't believe that part. We think he would. You know, or we're willing to assess a probability that he would. And we're willing to assess the possibility of $10 million. Seems like a reasonable calculation. Like, they can do that. Oh, Disney says, oh, they were looking at not casting them. Disney says, oh, they were looking at not paying him $300 million. We think Disney was lying. We think they'd do it. So one of the things juries get to do with their time is weigh the evidence and assess it and be like, yeah, we think they're lying. I'm not saying they do think they're lying. I'm just saying they can think they're lying because that's something juries get to do. While Mr. Depp's agent testified that Mr. Depp would get $22.5 million, yet also admitting there's no writing memorializing the supposed deal. Yeah, it seems this is kind of par normal, though, in Hollywood. People make deals and then reduce them to writing. So, yeah. He said that Mr. Depp would not be paid until the film shoots. Okay. Mr. Wiggum's belief there existed a contract was based on his understanding that Terry Jacobs, Mr. Depp's earlier agent, had negotiated a deal. However, Mr. Jacobs testified there was no deal negotiated, no commitment while she represented. Okay, well, maybe it was more, maybe it wasn't quite a contract, maybe it wasn't quite a commitment, maybe it was more of exploratory at that stage. The jury could think that exploratory means that it's going to manifest into a deal. I mean, they made 5 other Pirates movies. It's not exactly beyond the realm of possibility. The jury think, maybe they'll make 6. I mean, they made 5. Well, what basis do we think they're going to make 6? Well, they made 5. Especially on a civil standard of proof, I'd like to remind you, which is more reasonable than not. Right? We're not in a criminal trial. We're not beyond reasonable doubt. We're not thinking to ourselves, geez, you know, beyond reasonable doubt. Well, there's a lot of reasonable doubt here, to be sure. There's a lot of reasonable doubt, to be sure, but that's not the standard. The standard is more likely than not. 50.1%. What do you think is more likely? Do you think it's more likely, John, that they're going to make a Pirate 6 or not? I don't know. They made 5 of them. They seem to have done pretty well. It seems like maybe they make a Pirate 6. That seems like a thing they might do. On a preponderance evidence standard? Yeah. You know, I know. Yeah. Since the film has never been shot, let alone even written, yes, it's still in development, which means, incidentally, Johnny Depp might still be a part of it because it's in development, and it was not by November the 2nd, the date the damages are cut off, it would be impossible to claim damages for Pirate 6. No, because if they were thinking about him being in it and then stopped thinking about him being in it, those are damages, right? It wouldn't fully mature, but they've occurred. The damage has occurred. They were thinking Johnny Depp, and then thinking not Johnny Depp. That is a damage to Johnny Depp. The fact the movie hasn't been written, filmed, produced, distributed in theaters, it's like, well, they were thinking Johnny Depp and then stopped thinking Johnny Depp. That sounds like a harm to Johnny Depp to me. In terms of his reputation, in terms of money, seems to me. More importantly, there's no evidence the op-ed had anything to do with whether or not Mr. Depp will be in Pirate 6. Only if you're a complete idiot. The Disney corporate representative testified no decision maker within Disney has ever said Disney would not cast Pirate 6 or not based on the op-ed. Yeah, they don't usually say that. They don't usually say the quiet part out loud. This is true, incidentally, of most business dealings generally. It is a bit unusual, although certainly not unheard of, for a company to just flat out tell you why they're not going to hire you or something, right? Oh, it's because of this op-ed. That's the reason we're not making that decision. Most of the time, companies don't behave that way. Most of the time, they're just like, yeah, you're not getting the job. And you just have to speculate as to why. You have to guess. This is true, incidentally, in interpersonal relationships. Right. It's also typically true, although not, of course, for sure, that, I was ghosted by that girl or by that guy. And typically, again, they don't typically tell you exactly why. Sometimes, but not always. And sometimes if they do tell you, it's not really the reason. So yeah, it's like, okay, yes, no one testified that Disney ever said, yes, it's because of the op-ed. People don't act that way. People don't respond that way. People don't behave that way. They don't act that way in business. They don't act that way in the personal relationships. When they ghost you, they kind of just ghost you, and you have to guess why. And you know who else gets to guess why? The jury gets to guess why. They get to form all reasonable inferences. I wonder if it was because of the op-ed. I wonder if that was one of the things circulating through Disney's mind. Well, the op-ed existed, and Disney says we're not going to hire him. I wonder if the two might have had some sort of, effect on each other. That's what juries are for, to draw those kinds of conclusions, or not. That's what we get juries to do. That's why they get paid the big bucks of $50 a day to figure this shit out. That's why we pay them so much money. Yeah. In fact, while Disney had internal emails commenting on negative publicity relating to Mr. Depp, including the UK trial and judgment, and nothing is filed relating to the op-ed, much less a copy of the op-ed. Even Mr. Marks, Mr. Depp's expert, acknowledged the article published 3 days after the UK judgment indicating Mr. Depp was out of any further Pirates franchise. Okay, still, it could have had an impact on him, right? So even if you believe that much, it doesn't mean an impact. Because when we say he's out of the franchise, what exactly do we mean? Like, again, it's like saying someone's out of my mind. How much out of my mind it is? Like, are we on the borderline or not, right? It's like, oh, I'm not going to go out with that guy again. Okay, what exactly does that mean? Are we on the edge? Or I'm not going to go out with that girl again. Either way, it's like, are we on the edge or are we not on the edge, right? Is it like something like, well, it could change my mind or not? And then we hear one more piece of bad information. It probably changes our assessment that we had before. So whatever our assessment was before of our probabilities, right? We hear another piece of bad information, probably changed our assessment. Probably made it less likely than it did before. So even if we were like, yeah, we're not going to do this, it made it more likely that we're not going to do it. It further hurt his reputation, which is the thing we're trying to assess. How much did it hurt his reputation? How much more did it make him a vile in Disney's eyes? How much more did it make him a scoundrel and a disreputable character? Right? So, yeah. That's one of the things the jury gets to assess. If the jury based any aspect of its award on Pirate 6, this would have been contrary to the evidence. I don't think so. Prejudicially impacted by Miss Heard being prevented from introducing the judgment? No. Or the article 3 days later? No. Purely speculative? No. And was effectively prohibited because Mr. Depp was limited damages? No. Nor is there any evidence Mr. Depp lost any other opportunities because of the op-ed. Yes, again, only if you're an idiot. There's no evidence of any other films being lost to the op-ed. Well, we do have evidence from his agents and other managers that Mr. Depp was being regularly hired for the movies and then stopped. And in between, this article occurred. Maybe it's because of the article. If only we had a way to determine that. Oh, we do. It's called a jury. Okay. Mr. Wingham testified that Mr. Depp did not have any studio phones between December 18th and December 2018 and October 2020, but he did not testify it was the op-ed. He doesn't know, but you know. Instead, Mr. Carino, Mr. Depp's other agent, testified publicly surrounding the litigation was harmful to Mr. Depp's career. I'm sure it didn't help, that's for sure. Mr. Depp filed the lawsuit against his son in Wooten and against Heard in March 2019. Mr. Wingham testified there's a great deal of publicity surrounding the UK trial, and Mr. Depp had not been cast in any film since the UK trial. I wonder, it could be because of the UK trial, it could be because of the Sun article, it could be because of the Washington Post, it could be because Johnny Depp is too expensive, it could be for a whole host of reasons. If only we had some sort of group that could adjudicate this. There is also no evidence of any endorsements they lost or did not receive because of Mr. Epp. In fact, he's still in an endorsement deal with Dior, which he's had since 2015. There's absolutely no evidence demonstrating the op-ed causing damage. Yeah, only if you're an idiot and being purposely obtuse. Yeah. The jury had enough. It's not purely speculative. The jury is not allowed to speculate. They are allowed to draw reasonable inferences. Did they have enough? Is there enough for them to draw reasonable inferences? Sure. They heard lots of testimony from his business partners, from his accountants, from his managers, from Disney, from people Amber Heard put on the stand. Lots of people testified about the issues, about the movies and the deals he made or not made and the article, and lots of evidence, right? So, I mean, again, you're having to draw some conclusions in your mind, but are these conclusions speculative? Are they baseless? No, I don't think so. There's enough for a jury to draw a reasonable inference. And there's also the jury can believe and disbelieve witnesses in whole and part and fraction or any combination thereof. So they can believe Johnny Depp in whole and part. They can believe the accountants in whole and part. Disney in whole or part. Amber Heard in whole and part. Her experts in whole or part. Right? It's all for the jury's consumption. It's all for the jury to take this vast pile of stuff and to filter through it and decide what's real and not. Is there enough there for them to draw these kinds of conclusions without speculation? Yeah, I think there is. I think any argument to the contrary is farcical. For the 2,034 of you who are currently watching, I'd just like to say thanks and thank you to the 700 of you who have currently liked it. Let me just read a few super chats that have existed. Sink in Chief gave $2, said, can't Amber Heard appeal for $500? Again, there seems to be some dispute over the award. It does seem like she has to present a bond for the entire amount, so that does not seem to be true based on what we can tell. Joshua became a new member. Thank you for hitting the join button. Patricia became a new member. Thank you for hitting the join button. Sink in Chief became a new member. Thank you for hitting the join button and became an advocate. Thank you for hitting the join button again. Phoebes, who's been a member for 16 months. Love the way you break the legalese down for all of us. Been with you since before Rinhouse. So happy to see your growth. Well, thank you very much, Phoebes. That's very kind of you. Michael Sanger said, JD won fighting, an honorable fight. No innuendo, no breaking of rules, no underhanding. It may not be brought in everything. Mr. Drew will never understand. But they won the best, most honorable way. And Bowman said, Q question, can juries claim defamation to Team Amber Heard's implications? No, they can't. They can't claim defamation to their implications. Not for at least the reasons that members of the jury are anonymous. So it'd be a little bit hard to impugn them because no one knows who they are. And Ruth Mulby is a member for 2 months. Thank you very much. I'd just like to say, by the way, for those of you who are not currently subscribed, if you'd be so kind as to hit that subscribe button. If the subscribe button is red, it is angry. And it is angry with you because it wants to be a gray subscribe button. Help it become the gray subscribe button it was always meant to be. Hit that red subscribe button today. And as of at least today, you can now pay for other people's memberships if you're so inclined. So you can gift memberships to other people and help other people join the 99 Cents Club so they too can get their name on screen and get the cool little check mark by their names and so forth and so on. Let us return to reading more about this wonderful decision, this wonderful argument. All right. The jury's compensatory and punitive damages awards were excessive as a matter of law. Given the jury did not and could not award Depp damages for any financial or pecuniary loss based on evidence presented at trial, the only damages the jury could have possibly awarded were for reputational damages. Even though representative damages are non-pecuniary, a jury must award damages that result only from defendant's wrong and not from other causes. Well, geez, how do we determine whether it was from this cause or that cause? If only there were a way to tell. Moreover, reputational damages cannot be used to punish the defendant for all negative publicity a plaintiff has received separate from the alleged defamation. But that is precisely what has happened here, and was compounded by exclusion of evidence of the UK judgment. The UK judgment involves different parties, it involves a different paper with different circulation, defamation to different people, different readership, different reputations, different harm, and so forth and so on. The whole thing is dumb. The whole thing is dumb. I will give Amber Heard's team credit though, because someone asked, are they represented by a bad legal team? I will give their legal team credit for whatever problems they have, which are mostly the client, and many. I will give them credit because with the nothing, they are doing a fantastic job. So they are better in writing than they are in trial. So that's for sure. But at least for my money, and I say this non-ironically, this is very good lawyering. This is very good lawyering. They are doing the best they can with nothing. And with nothing, they're doing a very good job. So unironically, they are very, very good at writing. These are very, very, very good lawyers doing a very, very good job. Unfortunately for them, they can't win. But that's in no way going to preclude them from trying. Man, they are going to get on the field and they are going to play this game to the very bitter end. They may be behind 70-0. They may be being intercepted. The ball be being intercepted every single turn. But man, oh man, they're going to get on the field and they're going to play every inch of this game. There's something admirable to that somewhere. And they're trying their absolute best. It would help a lot if their client didn't suck ass. But these are very, very good lawyers. This is what very, very good lawyering works with. So at least as to this much, Amber Heard is getting every dollar she's paying for. They're trying, man. They're trying. They may be trying with nothing, but they're trying. Okay. There's no evidence of damage to Mr. Depp's reputation caused by Miss Heard's op-ed. Instead, Mr. Depp testified to damage the reputation was when Miss Heard obtained it, for which he cannot be compensated. Also, I have a special place in my heart because I do personally enjoy being on the defensive. I enjoy the feeling of working from behind. So I really kind of enjoy this on like a personal level because I really enjoy watching them work with when they're so far behind. And it's like, I want to be this good. I want to be this good. I hope in my dreams I'm this good. Because it's just like this is the kind of thing I like, is really working from nothing, and they're doing a really good job. So it is to be applauded on some level. They're getting their ass handed to them, but man, oh man, they're going to get on the field and they're going to try every bit of it. Mr. Depp began his testimony by informing the jury that he brought his case about 6 years ago. Miss Heard made some quite heinous and disturbing, brought these certain criminal acts against me that were not based in any species of truth. Mr. Depp then continued his testimony by describing how accusations from the TRO spread throughout the media. The news of this, her accusations, and sort of permeated the industry and made its way through the media and social media, became quite global, let's say. Fact, you will. I felt it my responsibility not only to stand up for myself in that instance, but also to stand up for my children, who at the time were 14 and 16, and so were in high school. And I thought it was diabolical that my children would have to go to school and have their friends or people in school approach them with an infamous People magazine cover with Miss Heard with dark bruise on her face. And then it just kept multiplying. It kept getting bigger and bigger. Mr. Depp emphasized his reputation had been damaged for 6 years, well before Miss Heard's op-ed. So it was my responsibility, I felt, not only to attempt to clear my name for the sake of, well, for many reasons, but I wanted to clear my children of this hard thing they were having to read about her father, which was untrue. It really taken full 6 years, and 6 years of trying times. It's very strange when one day you're Cinderella, so to speak, and in 0.06 seconds you're Quasimodo. Mr. Depp's testimony clearly established damages to his reputation occurred in May 2016 was not related to the op-ed. Well, some damage definitely occurred at that point, for sure. I mean, that much to be sure, yes. And this was not isolated evidence. Mr. Depp also testified that after the public became aware of the TRO in May 2016, the bad news about him was multiplying and multiplying and multiplying throughout the media, throughout social media as well, so-called sort of strike media or whatever. I was taken aback a bit. There were abuse allegations, and then there was alcohol, and there was drug and violence, and it was all right then and there before my eyes, spinning out of control. Mr. Depp testified that when Miss Heard obtained the TRO, he lost nothing less than everything. It's not exactly what he testified to. That's not exactly the timing of the thing. That's a misquote. Because when the allegations were made, when the allegations were rapidly circulating the globe, telling people I was drunken, cocaine-fueled menace who beat women, suddenly in my 50s, it's over. You know, you're just done. I mean, give him credit for trying. This negative publicity in 2016 includes articles from TMZ and People magazine that showed photos of the abuse alleged by Ms. Heard, which Mr. Depp introduced into evidence in his case. The negative publicity about Mr. Depp before Ms. Heard's op-ed includes such headlines as, okay, so we're trying to show reputational harm beforehand. Okay. All right. Apparently drunk Johnny Depp cut off at Hollywood's film award ceremony. Johnny Depp, friends and family seriously concerned about him. Here's why. Johnny Depp has a clear and epic sense of entitlement, ex-managers say. Johnny Depp, a star in crisis and the insane story of his missing millions. Mr. Depp reportedly drank heavily and was constantly late on new Pirates movie set. Johnny Depp's financial woes might sink the next Pirates of the Caribbean. Where did it all go wrong for Johnny Depp? After a string of flops and ton of bad press, Johnny Depp's star power looks as wobbly as Jack Sparrow on the plank. Pirates of the Caribbean, the diminishing returns of Johnny Depp. Well, I mean, show me any movie where that's not true. Show me any movie where number 6 is as profitable as number 1. I mean, there's always diminishing returns. But you keep going to the well as long as it's profitable. Why are all of Johnny Depp's movies suddenly bombing at the box office? Johnny Depp allegedly showed up drunk to movie premiere, reports say. The real reason Johnny Depp used an earpiece on film set. The trouble with Johnny Depp, multi-million-dollar lawsuits, a haze of booze and harsh and marriage gone very wrong, and a lifestyle he can't afford. Inside the trials of Johnny Depp. Vodka for breakfast, 72-hour drug binges, and spending sprees with that beggar belief. Ashley Bolshoff reveals why Hollywood are reeling over what's called Johnny Depp's career suicide note, and how can J.K. Rowling be genuinely happy casting wife-beater Johnny Depp in new Fantastic Beasts films. Mr. Depp admitted these articles were not because of Miss Heard's op-ed, they couldn't have been, but rather they all started when Miss Heard going to court to get the TRO with a bruise on her face and paparazzi. That was the sort of beginning of the ball rolling down the hill and gaining momentum. You know, you got to appreciate it on some level. It's like, yeah, you're trying. You're trying to show that his reputation was complete crap before the op-ed and that he's defamation proof. Which is, you know, a theory that can work, right? He literally can't be defamed anymore. So he's beyond the ability to be defamed. This is what you're trying to prove. You got some evidence that that goes to that aspect, and that becomes a question of law as to whether or not that's possible or not. I would suggest no. It's not, but you gotta commend them for trying. At least I do. I gotta commend it. You don't have to, but I'm going to. You can poo-poo them. I'm gonna say nice things about them because they're trying their lawyer best. It's like when you hire a lawyer, you want them to try very, very hard within the bounds of ethics, and they're trying very, very hard within the bounds of ethics. So, you know, I appreciate that. After 6 weeks of trial, Johnny Depp went back on the stand and reiterated this testimony, saying Ms. Heard's actions changed everything. He again did not say it was the op-ed, but the accusations from May 2016, claiming, I'd spoken up for what I've been carrying on my back reluctantly for 6 years. Mr. Depp not only did not rely on his own testimony to claim damages from May 2016 forward, Doug Bana, an expert hired by Depp, was asked to analyze the impact of the allegations of domestic abuse made by Heard as it relates to her 2016 restraining order, and then asked also to analyze publication of the alleged abuse in the Washington Post op-ed. Mr. Bania testified that analysis shows that prior to 2016 and the abuse allegations, Mr. Depp was not portrayed in a negative connotation. Then after the 2016 mark, the majority of those results turned into negative things about the abuse. Okay. And even then, more so after the op-ed, there seemed to be a kind of theme or flavor. And not only the abuse allegations, but his drinking and drug use. But Mr. Ban admitted his analysis cannot separate how Mr. Depp's reputations were impacted from the op-ed versus how it was impacted when Ms. Heard filed for divorce. These are not bad legal theories, by the way. And I think goes again to show the critical mistake made by Amber Heard. As has been commented by others, one of her critical mistakes was her counterclaims. It was a mistake. It was a mistake because it formed a distraction from where this is from winnable ground. This is winnable ground. This is winnable ground. If you go with this is winnable ground. If Miss Heard goes in and testifies to much less extreme abuse, it's winnable ground. Miss Heard could have won this case. This is winnable ground. It was Elaine Barodoff and Amber Heard who forced this case on unwinnable ground. And it was forced because of Amber. So, yeah. Apologize for allergies. I'm having a tough time today. In fact, Mr. Bana testified that Mr. Depp's Q scores, both positive and negatively, actually improved after the op-ed, meaning his reputation actually improved. Okay. Finally, Depp's counsel improperly emphasized to the jury it could find damages based on the obtaining of the TRO. Counsel began the closing argument not by discussing the op-ed, but by saying on May the 27th, 2016, Ms. Heard walked to a courthouse in Los Angeles to get a no-notice ex-parte restraining order against Depp, and in doing so, ruined his life by falsely testifying to the world that she was a survivor of domestic abuse. Today, on May the 27th, 2022, exactly 6 years later, we ask you to give Mr. Depp his life back by telling the world that Johnny Depp is not the abuser Amber Heard says she is, and hold Ms. Heard accountable for his lies. Counsel for Mr. Depp then went on to tell the jury that Ms. Heard seeking the TRO was not based on truth. It was said designed to ruin Depp. When she walked into court 6 years ago today, on May the 27th, to get the domestic violence restraining order against Depp, she did so in front of the paparazzi with a mark on her face. The evidence presented at trial demonstrated that Ms. Heard just didn't want a divorce. She wanted to ruin him. Like Mr. Depp's testimony and the evidence offered throughout the case, there were not isolated remarks, but permeated the entire closing. That Ms. Heard should be held responsible for seeking the TRO. That is when his life ended. That was 6 years ago to this day when Ms. Heard, on May 27, 2016, walked into court with her publicist, Joe Gottlieb, having tipped off TMZ with an alleged mark on her face to accuse Mr. Depp of abuse. It's about Mr. Depp's reputation, and about freeing him from the prison in which he lived for the last 6 years, and 6 years to the day. You heard from Mr. Depp yesterday being carrying these outrageous stories on his back pretty stoically, and living with them for 6 years and waiting to be able to bring the truth back. This emphasis on the closing was clear. Mr. Depp was asking a jury to compensate him for actions that occurred on May 27, 2016, actions in which he has no right of damages. I mean, he's got a point. He's got a point, man. He's going to play all the baseball in front of him, for sure. This is improper and calls for this court to set aside the verdict. See, this is where you're going to have problems, because you have to conclude a whole bunch of things. You have to conclude not only was it improper, but it was error for the judge to allow it, and it would have made a difference. That's a lot of things. You have to conclude it was improper. You have to conclude it was error for the judge to allow under the relevant standards, which, abuse of discretion, so good luck. And then you have to conclude it would have made a difference in the outcome. And this is why, appeals can be, appeals on these kinds of grounds can be basically impossible, right? Because you're trying to say, okay, the jury heard a whole bunch, you're trying to say at this point, a jury heard a whole bunch of things. Some of these things are confusing and off point. We'll take the premise. Some of them are confusing and off point. Some of them shouldn't be allowed. Some of them are going beyond the point. Now, I think you can attack the point because she herself brought it into significance by saying 2 years ago and what happened 2 years ago. So she's the one herself bringing it into focus. But let's say we get past that somehow and say we're making a mistake. Okay, so first step is we're going to have to say, all right, they were in error to bring this up because it's outside the window, even though the article itself refers to 2 years ago, and we're talking about things that happened 2 years ago relative to the article. So the article itself is kind of republishing it. So we're mentioning it because it's relevant to the article, which is in the context of the article. So you're revisiting this. So first of all, we have to conclude that's a mistake. We shouldn't have allowed that. Okay, second step. We have to conclude the judge made the mistake by allowing it, and we have to conclude the judge abused discretion by allowing it. It was an abuse of discretion for the judge to allow it. Okay, and then third step, we have to conclude that, yeah, it would have made a difference in the outcome. You see where this is a problem on appeal? People seem to generally be under the impression, because people say, I guess people hear, I'm going to appeal. I'm going to take this all the way to the Supreme Court. People seem to be under the collective misapprehension that appeals are just one massive do-over. Like, oh, we're just going to redo the whole trial, right? The Court of Appeals is going to fix this, right? The Court of Appeals is going to fix that. They're the one that's going to fix this. Props from the trial court. We're going to appeal. We're going to take all of this to the Supreme Court. Oh, they're going to appeal. Oh my God. So many things. And people don't seem to understand. No. That's really not what appeals are for. That's not what appeals are for. Appeals are not to relitigate the case. Appeals are for legal errors. That's what courts of appeal are for. If you're complaining about facts, you are complaining to the wrong court, ma'am. You are complaining to the wrong court. Courts of appeals are about the law, not about the facts. And so all you can do is go to the Court of Appeals and be like, oh, they made a legal mistake. Okay. So yes, they shouldn't have been allowed to reference this. It was too much. Also, the judge abused their discretion by allowing it, even though the court gets lots of discretion in trial management. The amount of discretion the judge gets in determining what witnesses will testify, what they'll be allowed to testify to, for how long, about what, is massive. People do not appreciate just how much power trial judges have. Trial judges have lots of power, right? This is one of the reasons they tell you to tell it to the judge, because the judge gets lots of power with their marionette-like strings over their case. The judge gets to control who will testify. Oh, you want this witness to testify? How about no? Even if they're within every rule of evidence, how about no? The judge can be like, why no? Why? Well, maybe it's repetitive. Maybe it's off point. Maybe it's confusing the issues to the jury. Maybe it's some other reason, right? Maybe it's too inflammatory. Maybe it's too prejudicial. Maybe it's this. Maybe it's that. So maybe it's just pure issue of time. This has been going on too long. No, you can't have that witness. No, you're just not going to have them. But I want them. They're really great. No. But okay, your witness can testify, but they can only testify about this stuff. But I want them to testify about these other things. No, they're only going to testify about these things, not these things, right? And now you have to get into the position where the trial judge, who has all this uber power, is in a position of abuse of discretion. It was an abuse of discretion for the trial judge to do that. This wasn't fair. This wasn't the trial judge. This was an abuse of discretion. They were just being a tyrant. And on all that, and you're going to get the Court of Appeals to agree to that. And then, one step more, on top of all that, and it would have made a difference. Good luck. Good luck to all that. This is why the rate of appeals, even in criminal cases, is like 2%. There's a reason the trial court doesn't get overturned 98% of the time. It's really fucking hard. So your fantasies of, I'm going to appeal, I'm going to take this all the way to Supreme Court. No, the fuck you're not. Who told you that? Good times. All right, so let's see. Where the hell was I? What page was I on? Let's see. Blah, blah, blah. Blah, blah, blah. All right, let's skip to part D of this bullshit. Do I have an Amazon link for my mic? Not a link to it, but the equipment is mentioned in the description below. All the equipment I use is mentioned in the description below. Although, if you were going to buy a new mic, I would recommend the RE20, which one day maybe I'll get because I think it is the best mic on the market. The Electro Voice RE20, I think, is the best mic on the market. That's just me. Unless you're going to spend uber money and get like a, what is it called? A Newman. But if you're looking at Newman level prices, then then you're way out of everyone's ball. No one uses a Newman. Like at all. So yeah, okay, if you're in that park, then yeah. But I think the best mic on the market is the Electro Voice RE20. That's me. Anyways, carrying on. The evidence demonstrates that any damages caused to Mr. Depp after the op-ed were not because of the op-ed. There are a number of alternative casualties. The most significant was surrounding the Sun's April 2018 publication in the UK for an article by Dan Wooten entitled, "How Can J.K. Rowling Be Genuinely Happy Casting Wife-Beater Johnny Depp in New Fantastic Beasts films?" Yeah, that's not at all like, causing the problem. Yeah. Mr. Depp brought a lawsuit against the Sun and Wooten on June 13, 2018, 6 months before the op-ed, because Mr. Depp wanted to clear his name, at least in the UK, sure. The exact same quest repeated by Depp and his counsel throughout trial. Yes, his name was hurt in 2 different places. The UK litigation resulted in a 3-week trial in London. As Mr. Depp's agent testified, there was an enormous amount of press surrounding the trial. Probably a lot of it in the UK. In fact, Mr. Bainey's analysis found the press surrounding Mr. Depp after the op-ed did not mention the op-ed at all, but instead were about the trial in the UK, which include the following headlines. Johnny Depp's disturbing alleged text messages read aloud in court as libel lawsuit begins. Let's burn Amber. Text allegedly sent by Johnny Depp read in court. Well, let's burn Amber, I think, is a sentiment many of us are growing to appreciate. I think it's a sentiment, burn the witch, I think is something that many of us have contemplated in the darker recesses of our mind. Hollywood nervously awaits fallout from explosive Johnny Depp trial. I bet they have. Yeah. Johnny Depp versus Amber Heard. All the nasty bits of the UK trial, and it's all nasty. Okay, thanks for saying that twice. Johnny Depp claims in The Sun he beat his ex-wife complete lives, court told. Uh-huh. All that good shit. Is this the same judge that gets to decide the appeal? No, we're still at the trial stage. For those of you who are confused where we are, we're in a motion to set aside the verdict. We're still at the trial level. We haven't appealed yet. Some people have misunderstood this to be the appeal. This is not the appeal. We are still at the trial stage. We're asking Judge A to set aside the verdict. We're still at the trial level. We're asking the judge, hey, judge, you know that verdict that you just entered, like just now? Have you thought about, not doing that? It should go about as well as you expect. I'm imagining the more likely result of this is probably a sentence or 2 or 3 of some version of no, go to appeal. I would not be surprised if Judge A is not particularly inclined to explain her reasoning at this point. So yeah. So we're still well at the trial stage of, hey judge, have you considered, like, not entering that verdict you just entered? Have you considered undoing that because it was a mistake? Sure, yeah, that's yeah. When and how will we hear a decision for this motion? It'll come pretty soon. I wouldn't worry about too much. Mr. Depp cannot, as a matter of law, be compensated for any injuries caused by anything associated with the Sun, the UK lawsuit, or the trial or the UK judgment. Yet, Mr. Depp's own expert could not separate how the reputation was impacted from the op-ed versus publicity surrounding the UK litigation. Yeah, to borrow a sentiment from Uncle the Bailey, who said basically the same thing. If only we had some sort of mechanism for this. If only we had some sort of mechanism to be able to separate the damages from the UK from the US. If only we had some sort of process by which we could consider the damages caused by the UK and or the Sun versus the US and or the Washington Post. If only there was some sort of way to present the competing possibilities to some sort of body which could consider that and possibly render some sort of adjudicative proceeding that would help us filter what happened where and who's responsible for what. If only such a process existed. Thanks to Uncle the Bailey for that joke. That's a classic. Nor did Mr. Depp present any other evidence that was able to separate damages. Yeah. Finally, the Depp claimed damage he had been damaged for the past 6 years, including throughout the jury verdict. Mr. Depp also argued this in closing. You heard from Mr. Depp yesterday. He's been carrying these outrageous stories on his back pretty stoically and living with them for 6 years and wanting to be able to bring the truth back. This completely defied Mr. Depp's representation in the court that Mr. Depp was only going to claim damages from December 18th, 2018 through November 2nd. You know who else told them that? It was in the jury instructions. It was in the jury instructions. They could only consider damages between those dates. So the jury only considered it between those dates because it was in the jury instructions. Right? Because one of our conceits is the jury follows the jury instructions. And we're certainly not going to ask the jury, and even if we could, we wouldn't do it because we don't do that, right? It's in the jury instructions. The jury considered them. They only considered it between those dates. They were told to. How do we know we did? Because we told them to. That's how we know. We don't pierce the veil. Are you out of your mind? It was extremely unfair and prejudicial for the jury to be told repeatedly that Depp was damaged for 6 years up to the present. While Depp represented the court, it was not claiming such damages. But it's relevant because you have to understand the op-ed, which itself talks about 2 years ago, which goes to 2016, and okay, fine. This prejudice is exponentially increased because Heard was denied the ability to introduce the Depp lawsuit against Sun and Wooten, resulting in an extensive 129-page judicial finding. I still have not reviewed that decision. Maybe one day when I'm bored and or need some content or something, maybe one day we will just read the 129-page UK decision and slowly lose our minds. Please like this video if that is a thing you'd like to see happen. Would you like to see me lose my mind by reading the UK decision on stream? If so, please leave a comment to that effect. Resulting in an extensive 129-page finding that Depp committed 12 acts of domestic violence against Heard, including sexual violence, and caused her to fear for her life. The verdict as to damages should be set aside. Oh, thank you for donating 5 gift memberships. Yes, Cynic in Chief donates 5 advocate memberships to viewers. Well, that's very, very generous of you. Thank you for hitting that membership button and for donating some gift memberships to other people so they too can enjoy the revelry that is Uncivil Law. You're all wonderful. Thank you very much. There have been several cases that found damages to be excessive in defamation cases, which are instructive here. When each case must be determined by its own facts, nevertheless true that verdicts of other juries which have to be approved by the courts represent the common or average judgment of mankind as to proper recovery. Ooh, very fancy language. Finding a verdict of $10 million to be excessive and multiple times the amount of any other damages award for defamations. Yeah, but Johnny Depp is kind of... even if $10 million is multiple times what has ever been awarded for defamation ever before, I don't think we have to figure out that hard to find it to be appropriate here for all those things. We still have not gone to the we have the wrong jury discussion. We still have yet to get that far. Thank you for all 2,100 of you who are currently here and watching. If you've not done so already, please remember to hit the like button. The YouTube does enjoy the engagement. For example, in Richmond newspapers, the Virginia Supreme Court sustained a remittitur of $900,000 from $1 million for defamation arising out of publication of a front-page article in the Times-Dispatch, which reported on complaints about plaintiff's performance as a teacher. While the court affirmed the judgment was the teacher was defamed, it held an award of $1 million would be excessive, and the evidence does not demonstrate they abused discretion in reducing the award to $100,000. I mean, abuse of discretion is a pretty hard standard. In Gazette, the jury awarded compensation of $100,000 for publication of advertisement accusing plaintiff of racism in campus newspaper of a university where the plaintiff was a protester. The Virginia Supreme Court held that $100,000 in damages bore no relationship to loss sustained by plaintiff. The verdict of $100,000 is so out of proportion to damage sustained as to be excessive as a matter of law. As defendant points out, Moore experienced no physical manifestation of any emotional distress. Moreover, he sought no medical attention for any condition resulting from the publication. In addition, there's no evidence that his standing with peers was diminished as a result. Actually, the evidence showed that Moore continues to be held in high esteem. Well, as to his particular fact pattern, maybe, but Johnny Depp is a little bit different as to his fact pattern. What fake juror? Oh, we haven't gone that far yet. We haven't gone that far. We'll get there. Similarly, Mr. Depp can point to no damages sustained from the op-ed as opposed to other unrelated events. The $10 million verdict is completely out of proportion with anything even remotely related to the op-ed, especially in light of the Sun article, the lawsuit filed by Mr. Depp, the ensuing trial admitted negative publicity, and adverse judgment in the same time frames. Two circuit courts are also instructive. In Thomas versus Pizamas, the court reduced damages of $350,000 to $75,000. The court found the damages award excessive because on March the 8th of 2016, when the defendant made the defamatory statements, plaintiff had already been unflatteringly portrayed in many articles criticizing him in the Virginia Pilot. As described above and admitted by Depp, he had been unflatteringly portrayed by at least 2 years. Yeah. That's an issue of discretion of the court. It's discretion. That court in its discretion authorized this damages. This court in its discretion is not going to. So you have to show abuse of discretion. It isn't enough. I want to make this absolutely clear for everyone to make sure that they understand. These kinds of decisions are within the discretion of the trial court. Trial judges have immense power. This trial judge in that case, in Thomas, that trial judge reduced an award of $350,000 to $75,000. In that judge's judgment, there had been other issues of other damages in other publications. So they felt in their judgment, the $350,000 award was too much in view of those other things and reduced it to $75,000. The Court of Appeals, upon reviewing it, said, okay, that makes logical sense. That's an issue as to that judge's discretion. The question is abuse of discretion for the Court of Appeals. The question is, did the judge have a reason, basically any reason, to reduce it? Could the judge have reasonably concluded $350,000 was too much and $75,000 was the right amount? Now, without knowing anything about the underlying judgment, you shouldn't have much of a problem concluding the answer is yes, because it's a lot of discretion. Right? You don't need to know much about the underlying facts. You don't need to know much about the underlying facts because the issue is, could the judge do it? Now, the issue might also be, could the judge not do it? right? Because it would be an issue of discretion. So suppose the judge had not done it. Suppose the judge had said $350,000 sounds like the right amount, and that had gotten appealed. Does the Court of Appeals reverse that? No, because it's committed to the trial court's discretion, right? So either way, the trial judge gets control, unless you can show they're batshit nuts. So that judge went from $350,000 to $75,000. Even if they hadn't done that, the Court of Appeals wouldn't reverse. The Court of Appeals wouldn't reverse for not reducing it, and the Court of Appeals wouldn't reverse it for reducing it. They wouldn't reduce it, they wouldn't reverse it either way, because the trial judge gets control. They're the one that hears the facts. They're the ones that hears the parties. They're the ones that sees everything. They're the one that witnesses everything, right? The Court of Appeals has a cold transcript. The trial court gets to hear more. Trial court gets a lot of power. Whether that's good or not, it's the law. As described above and admitted to Depp, he had been unfairly portrayed for at least 2 years. Yeah, so sure, yes. If this trial judge wanted to reduce the amount to some other number, she could. She's not gonna. And the Court of Appeals isn't gonna do any damn thing about it. So, I'm sorry, you got the wrong judge. There is a little bit of fate involved in this, because judges are in fact human beings. I know. It's a surprise to me too, but judges and lawyers are in fact human. And they have different judgments and different decisions. This trial would not have gone the same with any other judge. You can guarantee it. Just because they're different human beings. There's no way it would have been the same. It's impossible. They're different human beings. You drew this particular judge. She's a fine judge. That isn't to say that if they drew in a different judge, you would have also gotten a fine decision. You would have gotten a different decision. Maybe a radically different decision. And that might have been fine too. Because there is a bit of human enterprise left at the end of the day here. So, it's like, well, this judge is going to say no. And so, sucks to be you. It's kind of the end conclusion of that one. Sucks to be you. You got this judge instead of some other judge. Really sorry about that and all, but, not sorry enough to do anything about it. Here, the jury's award of $10 million is not consummate with damages. But rather appears to punish them. First of all, it's not punishment because it's compensatory, so it's definitionally not punitive. It can't be punishing because it's not punitive. It's compensatory, you idiot. That's the whole point. That's why you ask the jury the question separately. It can't be to punish. That's why they ask the question separately. How much compensatory? How much punitive? It literally can't be to punish. That's the point of the punitive damages award. It's to compensate. That's its point. Oh my word. From which, the same is true of the $5 million punitive. There's obviously a sense to punish far beyond the op-ed. Well, finally in Schlecker, the court found an award of $10 million in the defamation case to be excessive and reduced that award to $1 million. There, a broadcast corporation through its TV station aired inaccurate information regarding a plaintiff's arrest for conspiracy to distribute cocaine, namely that law enforcement officers found 50 grams of crack cocaine and 500 grams of powder cocaine at residence and business. Despite the finding of defamation, the court significantly reduced the damages because it found the defendant could be held only responsible for those injuries inflicted by defamatory portions of the broadcast, not for losses and injuries sustained from the attendant arrest, prosecution, and forfeiture, or from newspaper accounts and accurate portions of television broadcasts. Likewise, defendant could not be held liable for creating any emotional, mental health, or physical symptoms deemed to have predicated the broadcast. Okay. So here you have a guy who's arrested, charged, and prosecuted for some drug-related crimes. The newspaper apparently defamed him by saying the amount was wrong. Okay, the trial court said $10 million. Then the trial court said, how about $1 million? Because you can't get to those things like the arrest and the prosecution and you can't get to those things. You can only get to what's false, right? And so the false is not worth $10 million. It's only worth $1 million. All right. Notwithstanding these limitations, the jury awarded $10 million, an amount more than sufficient to compensate him for all his injuries. The most plausible explanation for the size of the award is the jury misperceived the law and instructions set out to punish the defendant in addition to compensating. The same is true here when it appears the jury was awarding them for everything from misstep to 2016 forward. Again, I can disagree with this legal argument as a judge, as a hypothetical jurist. Right? As a hypothetical jurist, I can disagree with this. But as a hypothetical lawyer, I admire it. Well, not as a hypothetical lawyer, I am a lawyer. As a hypothetical lawyer in this case, I guess I should say, I admire it. Because they are definitely reaching for everything. And I admire it. And this is extremely well written. It is everything you want this to be. It is extremely well written. It is well pled. It is well argued. It's well organized. It tells a story well, it cites the law well, it cites the facts well. It is doing everything a lawyer should do. This document, for whatever problems it has, is absolutely top-notch legal work. It is the best legal work. It is fantastic legal work. The fact it doesn't work doesn't preclude it from not being great legal work, right? It's like, they played the game and lost. They're playing the game and losing, but they're doing fantastically well. They're playing the game and losing because their client sucks ass. Their client sucking ass is not helping a lot. But this is absolutely top-notch legal work. And anyone who's looking to write, especially anyone who's looking to write a difficult position, anyone who's looking to write a hard-to-win position, this is great. This is great. It's not going to work. It's wrong. But it's fantastic work. They're trying their hardest. There's something admirable about that. There's a lot admirable about that. They're very good lawyers. They're very good lawyers, at least in writing. So, in fact, Depp's closing asked the jury to clear his name from everything through 2016 forward, which the court in Schleck held was an error, holding the excessive award is supported by a review of the plaintiff's counsel and remarks in summation. Instead of acting for compensation for proven losses, defendant's counsel, without objection, asked the court to require defendant's station to pay an enormous amount of sum to clear the good name. Mr. Depp's counsel asked him to give his life back, referring not to the op-ed by the entire thing. This is brilliant. This is brilliant legal work. I don't think I'm this good. I admire this. This is great legal work. On May the 27th, 2016, Ms. Heard walked into a courthouse in Los Angeles to give a no-notice ex parte restraining order against Mr. Depp, and doing so ruined his life by falsely telling the world she was a survivor of domestic abuse. Damages in this case cannot be based on actions from 2016 or any damage Depp suffered because of trial in the UK. But the jury's $10 million award in damages showed what the jury did. Okay. It's top-notch legal reasoning. It's top-notch legal reasoning. Who wrote this, by the way? Whose signature is at the bottom of the page on this one? Elaine? Elaine's signature is at the bottom of the page. If Elaine actually wrote this... her name is at the bottom. Her name is the signature at the bottom of the page. If Elaine wrote this, it goes to show why she's partner. If Elaine wrote this, it goes to show why she's partner. She had many, many problems at trial. Many problems at trial. But not every lawyer can be great at everything. But Elaine is great at this, so she should probably stick to what she's great at. Because this is great. I'd want Elaine as my counsel in writing. If Elaine's writing this, she's worth every penny she's getting paid. She's just not a very good trial lawyer, but she's a fantastic lawyer in writing. All right, let's take a look at argument number 2. Yeah, come on, Kurt. I'm serious. Gabrielle, I'm serious. I'm going to tell you how it is. Gabrielle Payton, come on. I am coming on. I'm telling you. I'll tell you flat out. I always do. I always tell you flat out how I perceive things. I'm not going to stop now. I was incredibly critical of Elaine throughout the trial. As you guys well know, you guys saw me being critical, and I'm willing to be critical of her now. Her trial presentation was a disaster area. Her ability to question witnesses, especially on cross, her ability to remain on task, she got flustered, distracted easily. She's not a very good trial lawyer. But if you think I'm going to tell you anything other than what I perceive to be the truth, you're out of your mind. If she's writing this, she is an unbelievably great lawyer. This is incredibly good. She's worth every penny she's making. And if that in any way displeases you, because it's not what you want to hear, I'm sorry. That's my opinion. I think she's fantastic in writing. Doesn't mean that I think she's fantastic other places, but, it's great. Fantastic. Yeah. The Virginia Supreme Court has held that jury verdicts are irreconcilably inconsistent and cannot stand. Okay. In that case, the Supreme Court has instructed that new trials necessary when portions of a jury verdict are irreconcilable. All right, so if that is the law in Virginia, which doesn't have to be, it's not necessarily the law in the federal system, by the way. Joe Scott says, does writing a lot that isn't going to make you a better lawyer in writing than a little and winning? Oh, she can't win. She can't win. So she's doing the best she can. It's like admiring a general on a battlefield who's, behind and just making fantastic choices. It's like, these are the best choices they can make. They're not going to win, but they're the best choices. It'd be great if she could win, but she can't win. So, if she could write less well and win, that'd be fantastic, but she can't win. She's stuck with an unwinnable position. But, she's trying. And she's doing a fantastic job. It might be, backwards army versus the US, but they're doing something right. Here, the jury verdicts in favor of Mr. Depp as to defamation claim in favor of Ms. Heard as to claim of defamation are inherently and irreconcilably inconsistent. And cannot stand. The verdicts found that Depp did not abuse Heard at any time, while at the same time necessarily found that Heard did not lie about being victim of domestic abuse. These findings are inherently inconsistent. Not true. They can be read consistently because the one is such a specific claim. It's totally possible to read them consistently. They're not inherently irreconcilable. I appreciate her trying, but no. In overruling Miss Heard's demurrer, this court held the statements. Miss Amber Heard, I spoke up against sexual violence and faced our court's wrath. That has to change. Then 2 years ago, I became a public figure representing domestic abuse and felt the full force of our culture's wrath for women who speak out. And I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. All could convey the same meaning, that Mr. Depp abused Miss Heard. In reaching that conclusion, the court held the inference could be made based on the events surrounding the parties' divorce, including allegations from May 2016, which were 2 years before this article was written. This holding means for the jury to have found Mr. Depp in favor of his claims, it necessarily had to find that he did not abuse him at any time, including May 21st, 2016. That's not quite correct. I appreciate them trying, but it's not quite correct. It is not quite correct the jury had to find that Mr. Depp never abused her. Right? Because what does it mean to be a victim of sexual violence? What does it mean to be a public figure representing domestic abuse? Is it enough that you were domestically abused or sexually violated once? Is that enough? That's a question of fact. I'm not taking a position on the issue. I'm saying how it could be read by a member of the jury or not. And a jury could think about it multiple different ways. Is it enough or not? Just to make it absurd, if you think that, grabbing someone by the arm and, pulling them away, if you think that's abusive, is it enough that it happens one time over the course of an entire relationship for that to qualify as being a figure, as being representative of domestic abuse? Is it enough? And that's a question of fact, right? If we were in a domestic violence case, if we were in a criminal case, if we were in a battery case, we'd be asking completely different questions and we'd be coming up with completely different answers. Yes, it's enough to be criminal battery. Yes, it's enough to be civil battery. And yes, it's enough to be violence in a domestic violence case. Is it enough in a defamation case? Well, how's that term understood? How would a person read it? What does it imply? And so forth and so on, right? So it isn't necessarily true that the jury had to find that it never happened. They could, although it's obviously harder, but they could conclude it happened and still not comprise domestic abuse. Because what that means is a little bit in the eye of the beholder in this particular situation, right? I'm making this clear, by the way. These are not my particular views or personal views, right? I'm not telling you what I believe. I'm telling you what I think is possible for someone to believe, what someone could understand it to mean. I think it's possible. So that's all I'm trying to claim. Moving on. Conversely, when a court overruled Mr. Depp's demurrer to Ms. Heard's counterclaim, it held the statement made on April the 27th about May 21st, 2016 incident implies Ms. Heard lied and perjured herself when she appeared before court in 2016 to obtain a temporary restraining order. She said she was representing domestic abuse, meaning her client is domestic abuse. She's talking about herself. She doesn't have a client. She's talking about herself. I don't know. This holding means for a jury to have found Ms. Heard in favor as to defamation claim, it necessarily had to find Ms. Heard did not lie about being a victim of domestic abuse. They don't necessarily have to believe that. They could, but they don't have to because of the context we're in. Mr. Depp himself acknowledged before the parties they're mirror images of each other. Okay. As the parties' briefs make clear, the parties' claims against each other necessarily implies that Mr. Depp either did or did not abuse Ms. Heard. Yes, but what does it mean to be abusive is the question. Is a question here. What does it mean to be abusive in this context? Right? If we were in a criminal battery case, we'd be asking a different question. If we were in a civil battery case, we'd be asking a different question. And if we were in a domestic violence case, we'd be asking a different question. We're in a defamation case. What does it mean to be abusive? Is a physical act necessarily abusive? This is a question a person could ask because of the context we're in. By finding defamation against both parties, the jury necessarily found that Depp did not abuse Ms. Heard. Not necessarily. Not necessarily. They could have believed abuse. Well, let me be a little bit. They necessarily found it wasn't abuse. That's true. But it doesn't mean that they didn't find physicality. At the same time that Depp did abuse Heard. These verdicts are irreconcilable and cannot stand. Not necessarily. And admit the jury's finding in favor of Ms. Heard necessarily precludes a finding of actual malice. Not necessarily, because the statements, each of the statements, can be assessed as to themselves individually. Yeah. Z-Dog says, talking about shooting a dead horse. I don't know if you're talking about me, Z-Dog, by the way, or not. But in these kind of circumstances, I need to be abundantly clear because I don't want to be misconstrued. So yeah, I'm going to say it a couple times in a couple different ways. Because I'm a guy on the internet and I've had my words misunderstood and mispresented before. So yes, I'm going to say it a couple times, a couple different ways to make sure the point gets home. Because I have to be careful because I've had my views misrepresented before when I'm not careful. So yeah, if you think I'm being a dead horse, I'll say it again because I need to make sure I'm being clear. The Supreme Court of Virginia has never decided whether facially true statements can support a claim of defamation by implication when they involve a public figure or matter of public concern. In Pendleton versus Newman, however, the court signaled this doctrine does not apply in these circumstances. In a footnote, there the court distinguished Chapin versus Knight Rider, where the Fourth Circuit held that speech at issue does not impart a defamation implication from the facts of Pendleton reasoning. In Chapin, the court considered the libel claim in which defendants were members of the press. The plaintiffs were public figures and some matter touched on matters of public concern. In these circumstances, the court held the constitutional protection of the press reaches its apogee Here, by contrast, the plaintiff was not a public figure. Defendants were employed by government agencies, but were not officials generally known. The publicity attending the subject matter lasted only a few days, and the freedom of press is in no way impacted. This reasoning indicates defamation by implication warrants different treatment when speech at issues involves public affairs or malice, or affairs. Well, it does, because you have to find malice. It also demonstrates whether the First Amendment permits recovery is a question of first impression in Virginia. Might be. That just means there's no precedent on it, so, okay. Several jurisdictions have held defamation by implication is not recognized as a viable cause of action when the statements issued public figures or matters of public concern. See, for example, Louisiana. Defamation by implication is actionable only if statements regard public individuals and private affairs. See, Minnesota. Statements about public officials that's true on its face cannot support defamation by implication. See, for example, Rhode Island. Finding plaintiff as a police officer is a public figure cannot recover on portions of damages alleged in defamation by implication. See, for example, New Mexico. The factual statements are true and therefore implication of misrepresentation cannot constitutionally serve the predicate for defamation complained by a public official regarding matter of public concern. See, for example, Colorado. The trial court did not err in concluding as a matter of law if the alleged libelous statements are true, there can be no libel by innuendo of a public figure. See, for example, New Jersey. We've adopted the view there's no libel by innuendo of a public figure where the challenge communication is true. See, also, for example, Louisiana. Truth may not be subject of either civil or criminal sanctions when discussion of public affairs is concerned. But see, Iowa. Bonus points. But see, Stevens versus Iowa, describing divergent authority on this question and concluding a public figure can maintain a suit for an implication. Okay. Elaine Baradhoff just earned all my respect points at once. She did something that she's absolutely required to do, and a lot of attorneys don't do. And she earned all my respect points all at once because she cited contrary authority, which she is required to do. She has to do it. But a lot of attorneys don't. A lot of attorneys play fast and loose. And so Elaine Baradhoff earned a lot of respect from me just now because she said, okay, look, this apparently is an issue of first impression in Virginia. Virginia apparently does not have this decided. Okay. Let's assume that's true for the moment. She said, okay, so how are we to rule on this? Well, she does what you would do in this circumstance. She looks to other authority from other states. And she cites a whole bunch of authority that stands for her proposition. Here's a whole bunch of states that have said no in this circumstance. And then she does the one extra thing that she's supposed to do, where she says, but here's a state that said yes. Here's a state that said yes. Respect. Nikki says she admits under oath it's about JD. That's not the issue here. The statements are literally true on their face. The question at the moment we're trying to decide is the defamation by implication. Okay? Okay, the question we're trying to decide this exact moment in this argument is whether or not defamation by implication against a public figure is possible. No one contests the statements are on their literal face true. The statements are literally on their face true. The fact they're about Johnny Depp gets you part of the way there, right? That's part of the question they're about Johnny Depp. But that's not enough. That is about Johnny Depp. That doesn't get you enough. The next step you have to get to is that the statements, although literally true, imply things that are not literally true. And that's where you run into a problem, right? That's where you run into a problem. And so not only is it about Johnny Depp, but it implies things, namely that Johnny Depp abused me is the implication. That's not there on the text. It's not. You have to assume that's what it's trying to say, but you have to assume it's what it's trying to say. So that's exactly the problem. So they're saying, look, here's a whole bunch of courts that have considered this. When it comes to private people and private matters, yes. But when it comes to public people and public figures, no. So because the statements are literally true, you can stop. Defamation by implication is not a thing, at least in these states. But then see Iowa that says, yes, it can be a thing. And so the question for Virginia is, well, is it a thing in Virginia or not? And if it's a question of first impression, then now you have a basis to go to the Virginia Supreme Court, where you didn't before. If it's a question of first impression, you have a basis to ask the Virginia Supreme Court for review. It doesn't mean that they will give review or not, but you have a basis to ask. Because what is the law? And if defamation by implication is not possible as a matter of law, then... right? That's the question. Is it possible as a matter of law? This is a great legal argument. And apparently there's no answer in Virginia, so, let's press on. Great shit, though. Other courts permit actions by defamation by implication of public figure only when the inference arises from omission of material facts. Similarly, courts that permit public figures to recover for defamation by implication generally define the tort as occurring when juxtaposition of a series of facts so as to imply a defamatory connection between them, or creates defamatory implication by omitting facts. Three rationales underlying these distinctions are instructive. I mean, this is just geeking out hard law. This is geeking out hard law right now, right here. Can I say it again? Not really. Not unless I've said it 3 times. Not unless there's a particular way you're getting confused. 3 rationales underlying the decisions are instructive. 3, first, precluding liability for facially true statements about public affairs is a corollary to protection of false statements published without malice. Second, as a result of their fame, public figures enjoy a platform that allows them to reach a broad audience when expressing viewpoints. With benefit comes a risk of closer public scrutiny than otherwise might be the case. Any article replete with snide innuendos can be hurtful and indeed damaging, but if they're a public figure, they must bear the risk of such publicity as the price they pay, quoting a case from the Southern District of New York. Third, when public affairs are concerned, the publication of true statements is encouraged, and there can be no civil or criminal liability, regardless of ill will or improper motive on the part of the speaker. As expressed in the op-ed, the public scorn inflicted by individuals who report abuse is a matter of great public concern. True statements should be afforded public protection. Speech about public figures and matters of public concerns lies at the core of the First Amendment. Given the First Amendment interests at stake and the reasoning described above, the court should hold true statements about a public figure or matters of public concern cannot support a claim by defamation by implication. In the alternative, the court should hold that when such speech is an issue, defamation by implication is permissible only if the defamation arises from juxtaposition of facts or omission of material facts in a challenged publication. Wow. I mean, that's just pure law. That's pure law, and that's hardcore geek, man. That's hardcore geek. It directly contradicts her argument that Amber retweeting isn't Republication. No, it doesn't. It absolutely, no way, contradicts it. No, it doesn't. They're completely different issues. Whether or not you're publishing it or republishing it, and whether or not those statements are actionable are 2 entirely different matters. You can believe one and not believe the other. Yeah, it's republication. It just doesn't matter. They're not actionable statements. Those aren't contradictions. They're completely separate legal issues. Is it republication? Okay, it's republication. Is it republication of something that's actionable? Those are entirely separate questions. They're not contradictory at all. How long is this thing? Pretty long. We still haven't gotten to the jury stuff. And we're in something that could win. This is winnable. This is legally winnable. And I don't know what the answer is. I'm not sure there is an answer. The Supreme Court of Virginia has to create one. So, fun times. But if the overwhelming weight of authority is against, you would expect the Supreme Court of Virginia to go against. So, yeah. Yeah. These are all legal arguments available to both Johnny's team and before the case started. It doesn't matter. That's what courts of appeal are for. A failure to execute a valid defense does not validate these arguments. They should resign. No, you're just wrong. That's what courts of appeal are for. That's exactly what they're for. Courts of appeal are for law. That's exactly what they're for. What do you think courts of appeal are for? These arguments were available before the trial, but that's not really what trial courts are for. I mean, trial courts have to make decisions about law, but that's not really what they're for. That's what courts of appeal are for. Trial courts are for facts. They're not really for law. I mean, they kind of do a little bit, but not really. That's what they should resign. These legal arguments were available. That doesn't make any sense. If what you're saying made sense, we'd never have appeals. What do you think courts of appeal are for, man? Speech about public figures and matters of public concern lie at the core of the First Amendment. At trial, Mr. Depp did not present evidence the statement at issue were untrue on their face. They're not. He proceeded exclusively on the theory of defamation by implication. True. He also did not attempt to prove alleged implication arose from juxtaposition of facts or an omission of material facts. Arguably true. There's no dispute Mr. Depp is a public figure. That cannot be denied. He's expressly admitted he's a public figure. Cannot be denied. He's tacitly conceded this point. It can't be denied. Moreover, this court has already ruled the op-ed addressed matters of public concern. Okay. Accordingly, they failed to prevent jury verdict should be set aside. This is a winnable argument. This is a winnable argument. Assuming you can appeal. Assuming you can appeal. Which is a whole other set of problems, but it's a winnable argument. I don't know if it will win, but it can win. Annie Oliver. I'm the only person that said it's winnable? Oh, I'm saying it's winnable because they made an argument that's right. Or it could be right. Right? I mean, I would have said it was unwinnable up to this point. If you'd asked me this morning, I would have said it was unwinnable, but I changed my mind because I read something. I don't know the degree to which other people are saying it's unwinnable, have or have not considered these arguments. I hadn't considered these arguments until this morning, or until like just now when I just read them just now. So if you had asked me this morning, I'd say, oh, this is unwinnable. And then I read it. I'm like, oh, wait a second. No, it's winnable. I read something and changed my mind. I don't know the degree to which other people who are reading this, I don't know the degree to which other people were saying it's unwinnable, have or have not considered these arguments. And maybe there's arguments to the contrary that make them unwinnable. Maybe this is, I mean, it's possible, because we haven't read a response from Johnny Depp. So it's possible that these are mischaracterizations of the law, or not the best way to consider the law. So it's possible I'll read Johnny Depp's response on this and I'll be like, oh no, this is the right response. Like, oh no, it's not winnable anymore. But I'm a lawyer and they made a legal argument. I'm like, oh, it's winnable now. So I'm like, I'm not in favor of Amber Heard or not. I'm just trying to provide good legal education. They made a winnable argument. What else do you want me to say? I don't know. And maybe someone disagrees with me. That's okay. If they have a reason why they think it's wrong, that's fine. I'm just giving you my assessment. And I'm not even saying that it will win, because they're, by their own admission, at least, they're saying they're saying there's no case law on it. So the Virginia Supreme Court has to make shit up. And they could easily, the Virginia Supreme Court could easily defer to the legislature. And be like, this is a legislative problem, fuck it. That'd be an answer. So I don't know, but it's winnable. Maria says, so it's not winnable? I said literally exactly the opposite of that. How are you not getting this? Are you just trolling me? To say it's winnable and to say it will win are two different issues. I don't know if it'll win or not. I don't know. It's winnable. They're in a winnable position now. They weren't 5 seconds ago. Now they are. I don't know if they'll win. Depends what happens next. Stop repeating? Well, Maria, you're the one who said, but you contradicted me, Maria. I'm talking to you specifically. Maria said, so it's not winnable. And then Maria said, stop repeating yourself. I was repeating myself for your benefit. Now I don't know what to do. Yeah, I don't know what to do. The jury finding of defamation by implication with respect to the op-ed headline is contrary to law and so unsupportable by the facts. The jury's verdict with respect to the headline should be set aside because under the applicable law, Mrs. Heard neither made or published nor republished it. They definitely did. To establish defamation by implication, Depp must prove the elements for each statement at issue, including first and foremost that Heard made the statement. There's no evidence that they ever made the headline statement. In the initial publication, sure. The undisputed evidence is they never wrote the headline. The newspaper added it without any involvement. Well, as to who specifically added it, it's unclear, but Miss Heard didn't write it, sure. Miss Heard played no role with the headline, fine. In fact, Miss Heard never even became aware of the headline until Depp filed the lawsuit. If that's true, that's just because you weren't paying attention. Miss Heard testified she didn't even notice it. Well, that's just reckless by you. In fact, there was a completely different headline in the paper edition, which Miss Heard had framed. Mr. Depp made no attempt to challenge this testimony. No reasonable jury conclude they made the headline statement given the evidence. Similarly, no reasonable jury can conclude that they published the headline. To prove publication, sufficient to show that when the defendant addressed the defamatory words, another person was present, heard the words spoken, and understood it as referring to plaintiff. Here, Miss Heard never addressed the headline to plaintiff. She never wrote or conveyed it. She therefore did not publish it. Virginia follows a single publication rule, under which mass distribution of defamatory communications, such as internet posts, are not deemed to be republished each time it's reposted or repeated. Fine. The public policy supporting the single publication rule and traditional principles are that a mere hyperlink without more cannot constitute republication. Yeah. Does one reasonable argument overturn all three counts? It would in this circumstance, yes. Now, if that's the right argument, it would overturn the entire thing. Yep. For the 2014 of you who are here, I appreciate all of you who are here. I'm sorry that sometimes I can't always tell you what you want to hear. Maybe it'll get better when Johnny Depp's team replies. It's always possible. We remain open-minded, as always. But I do appreciate it, and if you're liking this quality content, please remember to give it a like, because, you know, it is appreciated. So, yeah. Tweeting a link does not constitute republication even if a tweet includes mere reference. I think that's probably true. Merely retweeting definitely doesn't, and I don't think tweeting does either. Rather, republication requires editing and retransmitting the defamatory material or redistributing the material with the goal of reaching a new audience. Yeah, you're there, though. You're there on both counts. Stated differently, republication occurs when the speaker has affirmatively reiterated the statement. It's pretty hard not to be affirmatively reiterated. Initially, Miss Heard never edited or played any role with the headline. Moreover, a brief reference to the linked article does not constitute editing the article. She affirmatively reiterated it. Today, I published in the Washington Post is about as affirmatively reiterating as you can possibly get. Yeah. Interesting how your thoughts and Ian Runkle's are almost polarized on how this is written. Be that as it may. I respect Ian Runkle very, very much, of course. And he respects me. And we have a different opinion. Well, be that as it may. Moreover, although Miss Heard's tweets called attention to the article and indicated she was the author, the tweet did not edit or add content in manner sufficient to overcome the single publication. Yeah, it totally did. It's hard for it not to be more affirmatively republication than today I published. Today, the quote tweeting saying today I published, it's a little bit hard to dream up in one's fantasies more of a republication than today I published. Miss Heard also never redistributed the statement with the goal of reaching a new audience. Bullshit. Tweeting a leak to a prominent global newspaper article does not redistribute it to a new artist as a matter of law. Without more? Sure, but quite a bit more. Blah, 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 blah. In short, Miss Heard never affirmatively reiterated the headline. Today I published is pretty positive reaffirmation. A mere link and a brief reference to an online article is insufficient to constitute. Yeah, I mean, I suppose, yes, depending on what the brief reference is, possibly. Mere link, for sure. Brief reference, well, depending on what the brief reference is, yeah, maybe. When the brief reference is, today I published, though. Yeah, no. Moreover, there's no evidence reasonably supporting a finding Miss Heard republished the headline by tweeting a link to the global newspaper article. She has a different audience. It's her Twitter, and her Twitter, of course she does. Miss Heard has no control over whether her link to newspaper article is included in the headline. I bet she does. And also she could have affirmatively disowned it. Miss Heard never typed the headline in her tweet. She simply linked the article that did not restate the headline. Today I published. She could not have affirmatively read the headline. She didn't even notice her type. Bullshit. Bullshit. This is a crap argument. Like, if she had just, again, the case law as it exists deals with retweets, not tweets, but I wouldn't distinguish between the two. So if it is merely a tweet of the headline, if it was merely a tweet of the URL, I'd agree with her. If it's merely a tweet of the URL with some additional words, then, you know, quite possibly. Like, check out this article, or, you know, interesting article, or lol, funny article, or, you know, imagining like 100 different possible messages that, you know, are not enough, right? Merely the link by itself, I agree, is not enough. We can imagine 100 different messages she could write that, at least in our collective minds, we can say is not enough, right? It's not hard to conjure things where it's like, you know, it's just not enough. It's not enough. It's not specific enough. It's not enough of things. But it's today I published in the Washington Post. It's hard to dream. It's hard to dream of something much more specific than this, Amber. We appreciate your efforts and all, or Miss Elaine, we appreciate your efforts and all, and trying to distance herself from the tweet. But it's not like, you know, hey, how about that weather? Or how about those Mets last night? Boy, weren't they great in the baseball. It's today I published. I'm sorry, man. I'm sorry, but there's just no way on the face of this earth that does not constitute republication. If this is a winning argument, man, it's like, well, it's because you didn't mention the headline explicitly. Really? Really? I don't think so. All right. Mr. Depp did not present evidence of actual malice. I think she did. A public figure may not recover damages for falsehood without clear and convincing proof they are made with actual malice. To establish actual malice, a plaintiff must demonstrate... Whoa. I don't need 6400% zoom, but thank you. To establish actual malice, a plaintiff must demonstrate the defendant realized the statement was false, or subjectively entertain serious doubts as to the truth of the statement. Okay. Courts have a constitutional duty to exercise independent judgment and determine whether the record established actual malice. The rule of independent review assigns to the court a constitutional responsibility that cannot be delegated to the trier of fact, whether the fact-finding functions be performed in this case by the trier of judge or jury. Importantly, there's a significant difference between proof of actual malice and mere proof of falsity. Discredited testimony of the defendant, standing alone, does not constitute clear and convincing evidence of actual malice. Rather, the plaintiff must present affirmative evidence the defendant acted with the requisite state of mind. I think we're there. I think we're there. Conversely, a jury's finding the plaintiff's testimony is credible does not establish actual malice. In this case, proving actual malice required showing at the time of the op-ed, Ms. Heard did not believe she was abused or entertained serious doubts about whether she was abused. Yeah, but she didn't plead insanity. She didn't plead insanity or lack of mental capacity. Right? She didn't plead that she had the inability to know. That would have maybe worked, right? If she had gone in and pled, I'm insane, you know, I'm so confused and so deluded that, you know, I thought it was true in my own mind, regardless of what's true in reality, mind you. But I thought it was true in my own mind. Like, basically, I'm cray-cray. If she had went with I'm cray-cray, then maybe. But she went into court and said, yes, I'm a perfectly lucid adult. I'm a lucid, reasonable, educated person who knows things. I'm the man on the bus. I am the man on the bus. I am the average man on the bus, and I should be treated like the man on the bus. I'm like, okay. Okay, Amber Heard, you're the man on the bus. Fine. You're the man on the bus. You want to be treated like the man on the bus? That's perfectly fine. And then it's like, yes, I was punched and beat repeatedly. And then here's a picture of me the next day. And you're like, ah. So then it's like, did she know or have actual knowledge that what she was saying was false? Well, she's not crazy. So yeah, I think she could have been malicious. I think that there's clear and convincing evidence that she's malicious, that she knew what she was saying was false, or entertained serious doubts about, the whole being victimized with a bottle thing, because I didn't see it. Yeah, I think it's possible. Yeah. Is there clear and convincing evidence? I'm sold. Because actual malice is subjective, whether or not she was abused must be judged by her definition of abuse. No. That's not right. That's not right. But nice try. That's not right. The question isn't her definition of abuse. The question is her subjective impressions. But whether or not she was abused, okay. And then also, even if we would want to apply her subjective definitions, really, because her definition of abuse on the stand was, yeah. So if we really want to view this subjectively, based on what she views as her subjective definition of abuse, first of all, no. Second of all, are you sure? Are you sure that's what you want? Because, okay. If we're going to judge this based on her subjective definition of abuse, yeah, okay. Ms. Heard testified unequivocally that Depp abused her physically, emotionally, and psychologically. Under her definition of abuse, though, Mr. Depp presented no evidence that Heard did not believe abuse can be physical, emotional, or psychological. But she testified as to what she thinks the abuse is, and no. Ample evidence provides it can be abused for her. For example, Mr. Depp repeatedly asked Ms. Heard to cut him with a knife and threatened to cut himself in her presence when she refused to comply. Mr. Depp intimidated Ms. Heard by kicking cabinets and doors. While fighting with Ms. Heard, Depp pushed over racks of clothes and shoes in her closet and threw stuff down a staircase. Some other bullshit. The question is not whether the jury rejected the above conduct constitutes abuse as an objective matter. It's a little bit that. The question is subjective. It's whether Depp proved the abuse did not cause to believe she was abused. Under her definition of abuse? Under her definitions of abuse? No, I don't think she was abused. Under her definitions of abuse. Mr. Depp presented no evidence Heard seriously doubted she was abused. I mean, okay, no. Yep. Meanwhile, while domestic abuse is not limited to physical violence, undisputed evidence also established they participated in physical fights with and used force. But as to her definition of abuse, which is it? Is it her definition of abuse or is it an objective definition of abuse? If it's her definition of abuse, she has some real problems. Because her definition of abuse includes some pretty reprehensible things from which the evidence is somewhat lacking. Another recording, blah, blah, blah. All right, Mr. Depp did not present sufficient evidence to support a finding of defamation by innuendo. When a plaintiff claims he was defamed by statements that are literally true because of false implication, the implication must be reasonably drawn from the words actually used. In such case, the plaintiff may prove defamation through innuendo, an explanation of alleged defamatory meaning of the statement, if not apparent on its face. The province of innuendo is to show how the words are defamatory and how they relate to plaintiff, but it cannot introduce new matter nor extend the meaning of words used or to make certain that which is uncertain. In this case, the jury's verdict in favor of Depp should be set aside because they failed to prove through innuendo the appellate is about him and conveys defamatory implication. Yeah. When a plaintiff proceeds under defamation by implication theory, he must prove in light of circumstances prevailing at the time the statements were made, they conveyed a defamatory implication to those who heard or read them. Evidence is admissible to show circumstances surrounding the making of a publication, making a publication of a statement who would reasonably cause the statements to convey defamatory meaning. During opening statements, counsel for Mr. Depp forecast that, with respect to title, he would present no evidence of circumstances surrounding the publication that would suggest the title is about Mr. Depp. Counsel stated, after this lawsuit was filed, Ms. Heard started making more and more allegations of abuse. And if you recall, ladies and gentlemen, the headline of the op-ed refers to sexual violence, but Ms. Heard has never made that accusations against Mr. Depp. It was never part of her allegation. So what changed? We submit to you, and the evidence will show, when she realized the seriousness of what she alleged, she panicked and alleged sexual assault. In other words, Mr. Depp's theory was the allegations of sexual assault was made after the publication. Interesting. But still the issue is what it would convey to the person reading it, not to what she intended or not. So she says the allegations of sexual assault were made after the publication. As to Ms. Heard, maybe. As to what a person would read, though, at the time, that's the question. After commencement of the instant action caused the readers to understand the title to be about Mr. Depp. Whether or not it's about Mr. Depp has to be judged at the time that the article is published. It can't be judged on anything else other than that. So whether it's about Mr. Depp or not has to be judged based on the article and nothing more. But 2 years ago, I became a victim. The thing is, the 2 years ago, that's the thing that really screws her, is the 2 years ago. 2 years ago, I became a victim of domestic abuse. That's the thing that really screws her. Because what happened 2 years ago? She filed the TRO against Johnny Depp. So therefore, it's about Johnny Depp. That's the thing that really screws her, is that problem. So you have to say, like, that is going too far outside the publication to be by innuendo, which I suppose maybe you can do, but we'll see how it develops. In other words, the Depp theory was allegations of sexual assault made after the publication. This theory finds no support as contrary to Virginia law. Consistent with the opening statements at trial, Depp presented no evidence that prior to or shortly after the statement, Heard accused him of sexual abuse. Yes, but if that one sentence of the article reasonably calls into mind Johnny Depp, then the entire article is about Johnny Depp is a reasonable inference because it's within the confines of the article. So as long as you're there within the statement as long as you're there about the 2 years ago statement, as long as that's about Johnny Depp, a person could reasonably understand the entire article, including the headline, to be about him. So I don't think it works, but nice try. The only evidence of prior allegation was Ms. Heard's testimony in the UK that was provided confidentially when testifying about instances of sexual abuse. She also testified at the time the op-ed was published, she never publicly accused Depp. Not only was Ms. Heard's testimony about sexual abuse confidential, no evidence established it was made around the time of the op-ed. As such, they failed to show circumstances surrounding. Yes, fair enough, sort of, in far as it goes. So let's take the premise at the time of the op-ed, no one would have understood. Let's assume that prior to the moment the op-ed was published, no one would have understood Amber Heard to have made an abuse of sexual violence against Johnny Depp. This is the premise. At the moment the op-ed is published, no one believes that. Once it's published, what do they believe? As long as they are reading the statement 2 years ago, I became a victim of domestic abuse, as long as you're reading that statement and understanding that to be about Johnny Depp, so the whole thing is now conveying Johnny Depp, now you reread the title in that light, and you're there. So even assuming up to this moment she had never accused Johnny Depp of sexual violence, the 2 years ago thing totally screws her. It totally screws her because now, even assuming no one would have understood before this article that Johnny Depp had been accused of sexual violence, now you're putting him in the same breath as sexual violence, and now you have a problem. John said, what evidence did she present about abuse from JD? Well, depending on how you understand the term abuse, she presented quite a bit of evidence about abuse. But then again, the question is, how do you understand the term abuse? This is why also, incidentally, Ron Bourne had a winnable case. Because depending on how you understand the term abuse, depending on what it can be understood to mean, she presented evidence of abuse. For that matter, Johnny Depp himself presented evidence of abuse. Depending on how you understand the term abuse, Ron Bourne could have won this case. Unfortunately, and Amber Heard for a client who was driving Elaine into unwinnable places. There was evidence of abuse, depending on how you understand the term, sure. It just wasn't what Amber Heard wanted it to be from her own vantage point. This case was lost because Amber Heard forced this case into unwinnable territory. It would have won. Well, the sexual violence thing didn't help. That was really hard. I'm not sure how you get past that. Well, you have to play with the term, which is a little bit harder to play with, but you might have been able to get there. Anyways, pressing on. Further, nothing in the op-ed suggests the title was about Johnny Depp. The title said Miss Heard spoke up against sexual violence, which does not suggest she spoke up about violence against a particular person. The only sexual abuse discussed in the op-ed was the statement she had been harassed and sexually assaulted by the time she was of college age, well before she met Johnny Depp. So a jury could have found the sexual violence referred to that, but if they also found that Johnny Depp was talked about in the article, it could also be referring to that, and that's a question of fact for the jury. The title also has no temporal component, which is also a problem for her. And also the op-ed does not include Mr. Depp's name, because nothing in the op-ed suggests the title is about Depp. It presents no evidence of extrinsic circumstances suggesting it could cause the op-ed to be viewed about him. He failed to prove through innuendo the title implicates him. Yeah, if the title was all by itself, you might have a point, but the 2 years ago thing is kind of a problem. At trial, Johnny Depp's theories about defamation was the op-ed implied Depp abused Miss Heard. Mr. Depp maintained its implication arose from the op-ed because on May 27, 2016, she obtained a domestic violence restraining order. In sum, Mr. Depp argued the circumstances 2.5 years before the op-ed publication caused it to become defamatory. She's the one that wrote 2 years ago. So if 2 years ago she obtained the domestic violence restraining order, then yes, that invokes Johnny Depp, which invokes him. Now the whole article becomes about him and blah, 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 and you're there. No court in Virginia has ever permitted circumstances so distant from publication to serve as innuendo. Fair enough. It could be, right? So now we're talking like approximate cause theory. So now we're not talking about cause and fact. Now we're talking about proximate cause. And how deep do we want to how deep do we want the innuendo to be able to go? And that's what she said. Sorry. That was such a bad line. How deep do we want the innuendo to go? How many steps removed do we want this thing to go? And Elaine Bredoff says, okay, you're going too far. So it's like, okay, it's causal. In fact, it's just too far removed. You have to read the statement 2 years ago. I became violent of domestic violence. Okay, first of all, you have to assume it's reading about the TRO. Then you have to assume it's about Johnny Depp. Then you have to assume it's about Johnny Depp domestic abuse. Then you have to read the title in that light. It's just too many steps down the causal chain. Too many steps down the causal chain for it to be recognized as a matter of law. This is winnable. This is a winnable argument. This is proximate cause, is what this is. This is proximate cause. And Elaine Bredoff has said, this is too far. And the proximate cause line should stop sooner. This is a winnable argument. If the Virginia Supreme Court was inclined to go down these lines, which they're well incentivized to because of the other courts that apparently have agreed likewise, even if they weren't inclined to go as far as the other courts have, they have a reason to stop sooner. This is a winnable argument. This is proximate cause. This is winnable. When the publication does not show its apparent on its face, the publication is not actionable unless the allegation is short contemporaneous facts connect the words to the plaintiff. Statements or publication by the same defendant regarding one subject or event and made over a relatively short period of time, some of which identify the plaintiff, others which do not, may be considered together for the purpose of establishing the plaintiff was of or concerning. This is like Johnny Depp's theory, basically. That they're close enough in time, I mean, they're in the same article, some of which identify the plaintiff, maybe not that clearly, but 2 years ago, right? And so therefore, you're there. This is Johnny Depp's idea. But because Mr. Depp explained no evidence that within a relatively short period of time, the abuse, they failed to prove. Well, this is the wrong argument for the right legal theory. right? The issue is they are close enough in time, they are close enough in proximity in terms of them being proximate within the article, but the chain of logic to get to it was Johnny Depp who sexually violated me is like 4 steps down or 3 steps down. It depends how you count, right? How do you count this? How many steps removed are you in order to get to the articles about Johnny Depp sexually violating me? All right, so how many steps removed are you? Okay, first of all, you have to read the 2 years ago, I became a victim of, 2 years ago, I became a representative of domestic abuse. All right, first of all, you have to read that statement, not on its own literal terms of 2 years ago, I became a representative of domestic abuse, because 2 years before that, she became an ambassador for the ACLU. Right? So that is one way that could be read literally on its face, right? So step 1, you have to read 2 years ago, I became a representative of domestic abuse, not referring to literally her becoming an ambassador for the ACLU or not whatever, but referring to the TRO from 2 years earlier. So you have to read it as referring specifically to that. Second of all, you have to read it now talking about specifically Johnny Depp within that context. Third of all, you're talking about the domestic abuse of Johnny Depp himself. Now, fourth of all, within the context of all that, you have to reread the title, which up to this point, and we're assuming this for the purpose of argument, up to this point, there's been no allegation of Johnny Depp having committed a sexual assault. So now, fourth level, you're now having to read the title, sexual violence, as referring to Johnny Depp, based on the TRO, based on the thing, and you're like 3 or 4 steps removed on proximate cause land, and basically you throw up your hands and be like, it's too far removed. It's a winnable argument. It can win. It's a great argument. Elaine Bredoff is milking every dollar she has out of this. Not all of her arguments are winnable. This is a winnable argument. Whether it will win or not, these are questions of law, to which apparently Virginia has no answer. According to Elaine, Virginia has no answer on this question. So Virginia has to make something up. And so, like, well, why not make up the answer for me? Lisa says, it's approximate cause. JD's team produced witnesses to corroborate the article did just that. So is it winnable? You have to understand, okay, the question is not what the article is about in fact, right? So the testimony for me, like, the question is not, was the article about Johnny Depp in reality? Because you have testimony about that. You have it from Amber Heard, for Christ's sake. You have it from ACLU. So if your question is the article about Johnny Depp in reality? The answer is yes. Clearly, it's about Johnny Depp in reality. Amber Heard says it's about Johnny Depp in reality. The ACLU says it's about Johnny Depp in reality. Of course, the article's about Johnny Depp in reality. But the question isn't about what it's about in reality. The question about is what it's perceived to be. Because this is all about defamation. Defamation has to be communicated to a third party. Defamation has to be communicated to a third party. So the question isn't reality. The question is perception of reality. Because the defamation has to be communicated to a third party. So the question isn't what the article really means to Amber Heard or the ACLU. The question is the defamation to the third party. The question is, what does the third party understand the article to mean? So now we're no longer about reality. Now we're about perception. What is the perception? And this, again, goes into those questions I was talking about earlier. Like, what is abuse? What is sexual violence? What do those terms mean? What can they mean? What's available for a jury to decide? What could they mean? Could they mean that? Could they mean this? Does it necessarily mean anything physical? Does it mean that? Does it mean this? Right? These are all questions of perception, not questions of reality. Because the defamation has to be communicated to a third party. The question is, what does the third party perceive it to mean? Not what it is, but what is its perception? So, all that testimony from Amber Heard about what it's really about goes out the window. All that testimony from the ACLU about what it's really about goes out the window. All that testimony from these people about, like, about whatever goes out the window. We have to by law, put ourselves in the shoes. What we have to do is we have to put ourselves in the shoes of a person who's reading this article the day it's published, and what do they think it means? We have to all roll our minds back in time. We have to remember what we do know and what we don't know at the times that are relevant to the article, right? So we all have to mentally roll our minds backwards and go backwards in time and pretend that we're a juror reading this the day it's published. And what does it mean to us? We don't know anything about the ACLU testimony because it hasn't happened yet. We don't know anything about Amber Heard's testimony because it hasn't happened yet. It doesn't exist. The testimony doesn't exist yet because we're backwards in time. So the question is our perception. What does it mean in our perceptions? And can we get there or not in our perceptions? And how many, and also as a matter of law, how far are we willing to go? For those of you who are law students in the chat, this is Paul's graph. The very fact I say Paul's graph makes all the law students in the chat very happy and or very sad. This is Paul's graph. How far are we willing to go? How many steps are we willing to go? How many steps are we willing to go? Paul's graph is a great case, dealing with how far are we willing to go and how far are we not willing to go. Paul's graph is a woman running to make a train in New York City. This is like circa 1930 or something, okay? This is like, or maybe it's circa 1910s. It's a long time ago, okay? Paul's graph is a woman circa 1910, circa 1930, something like that. Paul's graph is a woman running to make a train. Meanwhile, a different guy is trying to hand a like suitcase or a box to the train conductor. The train is already in motion, mind you, and he's trying to run alongside the train. Well, actually, Paul's graph isn't running for the train. Paul's graph is just standing there. Paul's graph is just standing on the platform. Let me get this right. Paul's graph is standing on the platform. She's a woman standing on a platform, okay? She's just standing there on the platform, okay? Meanwhile, a different guy is running for the train. The train is already in motion, okay? He's trying to hand a box to the conductor to put on the train. The conductor drops the box. Unfortunately, the box is full of dynamite. Seriously, this actually happened. It's Paul's graph. Look it up. Okay, the conductor drops the box full of dynamite. The dynamite explodes. The explosion causes, explosions to explode, and there is a scale on the train platform. It's one of these big ass scales for weighing things, like really big things, like cargo. Okay, it's a big ass scale for weighing things. Okay, the explosion of the dynamite causes the scale to tip over and hit Paul's graph. Paul's graph is permanently wounded. She is crippled for life. She sues the train company because of the dynamite explosion. The Supreme Court rules that Paul's graph cannot recover. It is too far down the chain of causation. It is too far down the chain of causation. It was the box, the dynamite handed by the guy to the train conductor, which dropped and exploded and caused the scale to tip over and hit her and blah. It's just too many steps. It's too many steps in the mousetrap equation. And so we're going to cut it off. We're going to cut it off at some point in this chain of causation and say, no, we're not going this far down the chain of causation. We are stopping. And Paul's graph just loses. Right? No one can test that the explosion of the dynamite blowing up caused the thing, but it's like, it's just too far. And Paul's graph is just crippled and shit out of luck. So this is Paul's graph. This is Paul's graph all over again. Right? Instead of Paul's graph being a woman standing on a train station, as a guy hands a box of dynamite, instead of that, we've got Johnny Depp. All right, so it's Paul's graph all over again. We've got a box of dynamite known as an article. We've got an article being published, and it says this thing and that thing and this thing. And it says 2 years ago. Oh, we must mean 2 years ago. Oh, we must mean the TRO. Oh, we must mean Johnny Depp. Oh, we must mean the physical assault. Oh, I remember the picture of the physical assault. Oh, we must sexual violence, and we must be reading it in light of Johnny Depp. Oh, it's Johnny Depp who committed the sexual violence. And it's like like too many steps down the chain of causation. So it's just Paul's graph all over again. Where are we going to stop the chain? And that's the argument. I can't believe I'm geeking out this hard about Paul's graph, but it's a great case. It's a great case. Too far down the chain of causation. Yeah. It's good for your bar prep review. Yeah. Proximate cause, baby. Proximate cause. First of all, the court rules there's no duty to Paul's graph directly, and then rules proximate cause is too far attenuated. Yeah. And Drama points out quite correctly, people don't understand each state is its own. Absolutely true. Absolutely true. So, absolutely true. So where will Virginia draw the line? Where will Virginia draw the line? Paul's graph can't recover in New York. Can she recover in Virginia? I guess we're going to find out. Yeah. Yeah. As explained above, Mr. Depp's theory of the case was on May the 27th, 2016. Miss Heard ruined his life by going to a courthouse and obtaining a restraining order against him. It's sound law in Virginia that words spoken or written about a judicial proceeding are relevant and pertinent to a matter under an inquiry. They're absolutely privileged. In addition, because defamatory statements are subject to a 1-year statute of limitations, statements made by the restraining order are time barred. Yet, Mr. Depp has attempted to bootstrap his argument they are protected by judicial immunity and time barred through a relative statement of implications. Abusers always seem to have the law on their side? No, not at all, my friends. It's the law. The law's not like that. The law's neutral. I mean, just from a logical position, it's got to stop eventually. It's just got to stop. I mean, how far back do you want to change the? How far back do you want a butterfly affect this thing? Right? It's a reasonable question. How far back do you want to go? I mean, everything has causal factors back somewhere. Do you want to trace everything back to Adam and Eve? I mean, how far back are you willing to go? How far back are you willing to trace the cause of causation? You know, how far back? How long should these things persist? How many steps removed before it's just too many things? Oh, my friend Billy talked to my friend Bob, who did this thing to James, who did this thing to Steve, who did this thing to Kevin, who did this thing, who did that thing, who did this thing, who did the other thing, and how far back are you willing to go, man? And it's like the courts have just said, it's got to stop at some point. So, that's and then the question is, well, how far back? And then it's like, well, ask your state Supreme Court, how far back is right for you? Yeah, Mr. Depp attempted to bootstrap arguments that are protected by judicial immunity and time bar. At this point, by the way, if you have not already liked and subscribed, if I could be so kind as to ask, because I feel like I've earned it. I try to give you good analysis and good stuff and try to explain some stuff, and I get to geek out on Paul's graph pretty hard, and so if you haven't liked and subscribed already, please do all those things. I promise I'll give you more good commentary as things develop. You want to trace everything back to the lightning bolt in a pool of amino acid? Yeah, I'm not so sure about that one. I'm not sure your quest to sue the amino acid is viable, but you do you. The law is not neutral? Oh, it's very neutral. What makes you say the law is not neutral? The law is incredibly neutral. I disagree completely. The law is neutral. It has to be. There's no alternative. The rules of the game are neutral. You don't think the rules are neutral? I think the rules are neutral. I don't understand what you mean. Yet Mr. Depp attempted to bootstrap arguments that are protected by judicial mandate and time bar through the op-ed, through a claim of defamation by implication. This attempt failed because only implications that can be reasonably drawn from words actually used are actionable. Viewing the light most favorable to Mr. Depp, the most evidence that anyone could show is if a reader was previously aware of restraining order, and the statement, 2 years ago, I became a public figure representing domestic abuse, could remind such a reader that Miss Heard obtained the restraining order. But reminder statements made in judicial proceeding do not amount to republication of those statements. Interesting idea, citing Eastern District of Pennsylvania. I don't know whether or not that's a viable idea in Virginia or not, but the idea that they're not republication because those statements originally were made as a privileged communication in a judicial proceeding. I like the idea, though. Popcorn Planet is being attacked for years ago stuff. The question is Popcorn Planet the one who did it? Right? Right? And there's still statute of limitations issues. So, like, proximate cause just deals with how far down the chain of logic you want to go, how far down the chain of causation. If Popcorn Planet is being sued for things they themselves did, then you don't have a proximate cause problem. If they themselves did it, which is, I'm assuming for the purposes of this exercise, then your issue isn't proximate cause. Your issue might be time barred, but it's a different issue. All right? It's a different issue. Paul's graph is not in the Bible. Ha 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 ha. No, it's not. It's not. Oh my God. All right. I think the trail ends at what is causally relevant. Well, Abel, that might be the most not helpful statement I've ever heard in my life. Abel says, I think the trail ends when it stops being causally relevant. That might be the most unhelpful statement ever. When would that be, Abel? When would that be? That's kind of the exact problem we're trying to solve. Good times. Fake juror, we'll get there eventually, man. We have other stuff to go through, man. We'll see how far it goes. Yeah. You know? Okay. All right, so let's go ahead and go to the fake juror thing since it's next. That's fine. All right, the court should investigate whether juror 15 is a fake juror. This might be an all-time first. I'm not sure I've ever seen this issue ever in any court proceeding. This might be a first. I think I'd remember this one. So, okay. The court should investigate whether juror 15 is properly served on the jury. On the jury panel sent to the counsel before voir dire, the court noted the individual who would later be designated juror 15 had a birth year of 1945. Juror 15, however, was clearly born later than that. Publicly available information says that he might have been born in 1970. This discrepancy raises the question whether juror 15 actually received the summons for jury duty and was properly vetted to serve on the court. Okay. The Virginia Code provides that at the time of the assembly, for the purpose of juror selection, the identity of each member of the jury veneer, which is the big-ass panel you start with, shall be provided as provided. Prior to the selection by the jury veneer, a potential juror shall verify his identity by presenting blah, 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 blah. Thus, the circuit court office had a statutory obligation to verify the identity of juror 15. But because juror 15 was not born in 1945, it appears identity could not have been verified through any means the code provides. It also raises question about whether and how juror 15 could have signed a statement affirming under penalty of perjury that he was the named juror if he's 25 years younger. Although the Virginia Supreme Court has previously constituted the law as being directory rather than mandatory, it's observed that adherence to the provisions is required to the extent necessary to ensure with due process, and therefore follows that adherence is necessary to present due process. Now, that's just assuming it into existence. And then you have this nice little footnote. Ms. Heard recognizes the code states that any error in information shown on the jury panel shall not be grounds for mistrial or assignable error on appeal, and the parties in the case shall be responsible for verifying the accuracy of the information. Sounds suspiciously like a you problem. But the apparent error in the jury information form relating to juror 15 is not the basis for Ms. Heard's concern. It's not. It's the potential that juror 15 was not in fact the same individual the court assigned. This would warrant status. No. And this is just the first time this is coming to your attention? No. No. Just bullshit. To the extent the individual who served as juror 15 was not in fact juror number 15, or the clerk office did not verify the identity, Ms. Heard's due process was compromised. I don't think so. The Virginia Code does not contemplate jury service by someone not on the veneer for good reason. In any case, but especially a high-profile case, why especially, it is critical that to ensure no person who is not on the veneer is able to serve on the jury, whether by inadvertence or intention. Here the facts show juror 15 was decades younger than the individual in the jury, raising questions as whether or not they were the same or different people. Ms. Heard therefore requests they investigate it. No, and therefore we want to set aside. All right, so I assume none of this is going to work before this judge. I assume none of this is going to work for this. Not for the least of reasons, incidentally, that to the extent there are novel questions of law, this jury This judge can resolve the questions any way they like because it can't possibly be an error yet because the law doesn't exist. So, yeah. So, but on the appeal, there's some really interesting arguments here. So we'll see how this stuff. Mary said, he spoke to all these articles, hit pieces by the media, different than the op-ed. The jury has spoken. The op-ed blew it up. They didn't give him $50 million. Yeah, and that's part of the reason why. Perhaps exactly assessing damages to other places. Robin M., new member. Cynic in Chief, 5 gifts. Thank you for the gifts. Cynic in Chief. Lori became a new member. Thank you for hitting that join button. Terry became a new member. Anthony Cole became a new member. Hazel became a new member. Thank you very much. Wheat Chick, please do the UK verdict. I might have to. Always Tanaka became a new member. Thank you for becoming a supporter and hitting that join button. Hail Picciano said, does one winnable argument overturn all 3 counts? Yes, it would, absolutely, in this case. Mega became a new supporter. Thank you very much. Sue Candle says, as someone who lost confidence in legacy media because of this case, I'm extremely appreciative of your honesty and the ability to recognize a good argument when you see it. Truth first, bravo. Thank you. Beverly Wright gives $1. Hail Picciano became a new supporter. Lisa Rodriguez says, as for proximal cause judgment, JD's team produced witnesses corroborate the argument did just that. So is it still winnable? Yes, it absolutely is, because the question is, where do you stop? And that's just a question of law. Hail Picciano says, the jury did that. They said yes, but they might have been answering the wrong question. Mama a 6 says, Kurt, I don't understand. Amber Heard admitted it was about Depp. Yes, but that's not the question. Because you're saying, what is the article about in reality? The question isn't about what the article is about in reality. The question is about what is its perception, because it has to be communicated with third party, and that's necessarily a question about perception, not about reality. So her admission it's about Depp is irrelevant. Lisa Rodriguez says, thank you, but I'm saying JD produced evidence that third parties did perceive the articles about him and blacklisted as a result. Possibly, yes, and there's something to that result. But even if that's true, that's cause and fact. Right, you could still answer the proximate cause question differently. Causality comes in 2 forms: cause and fact and proximate cause. Right. The difference is, a Rube Goldberg machine. You've seen a Rube Goldberg machine, right? You tip over a thing that hits a thing that hits a thing that does this thing that does the thing. It's an overly complicated machine that produces a fantastic result. You hit over the domino that causes the bowl to roll, that hits the weight, that causes the spring, that hits the clock, that causes the toaster to do, and blah, 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 blah. So that's a Rube Goldberg machine. So basically what you're saying is the jury found cause and fact. The jury found that because the first thing, the end thing happened. Yeah, the question is, should we stop counting at some point along the way? Should we stop saying that at some point it stops counting? And that's a different question than cause and fact. Hal Pacino said, abusers always seem to have the law on their side. Disagree. Ian Kinsel says, I want to trace everything back to lightning bolt and a pool of acid. No. Okie dokie says, it depends, doesn't? Popcorn plants being tapped for years ago. The question there is statute of limitations, not proximate cause. Nicole gave $4.99 to say hiya. Hello, back. Hal Picciano said, she lied, he suffered. I'm a DVSA survivor. My abuser got off technicalities the first time too. The law is never on the side of victims. I disagree. And to the extent I agree, it's correct. Because the law is always in favor of the accused, because the law is trying to take away something from the accused. The law presumes everyone innocent. So to the extent that we are biased, yes, the law is unbiased in favor of the accused. And it should be. Because the state is the one trying to take away someone's freedom, or trying to take away someone's money, or trying to take something away from somebody. So yes, the law should be biased in favor of the accused. This is correct in my view. I am sorry for your own losses, but the state should not be able to take things away from people without being able to make their burden. Jen D08 says, thanks for all your insight, much appreciated. You're welcome. Roxanne Wynn says, let's say she retries it and JD brings more evidence and more witness. She'll get even worse around. This Court of Appeals might nip it in the bud depending on the rationale. Okie dokie says, it's really interesting and informative. Thank you for bringing some balanced objectivity. No worries. And for the 1,871 of you who are currently here, thank you very much for your being here and contribution. Yeah. And this motion, Judge A is not going to grant this. She has no reason to. She literally has no reason to. she would be presuming the very legal answers the Court of Appeals needs to decide. So she needs to kick it up and go from there. But I really, really like this. I really, really like this legally. And if these are the grounds they're going with, there are some winnable grounds here. Proximate cause is winnable. And the defamation by implication is winnable in view of the relevant authorities. So there are some winnable issues at law here. And then it's just up to the question of what does the Virginia Supreme Court ultimately want to do about it. And the Virginia Supreme Court is going to have to decide maybe where the line is. And I don't know what's going on. Tanesha says, I'm not a lawyer, so I understand about 10% of what you're saying. On some level, that's disappointing. I try to break it down more so that people understand it. I try. Hello from Norway. Nice to have you here. Amber Heard called Johnny Depp out to do an hour-long interview. I saw that. The jury is allowed to come to any decision it chooses. Within the bounds of evidence, yes. It was a unanimous verdict. Heard has no right to question the verdict or why they came to the verdict. Sure enough, but they have the right to determine whether or not the right law was applied. So, that's what courts of appeal are for, is to determine whether or not the right law was applied. So we'll see how it goes. It's not winnable in the court of public opinion. I tend to agree. I don't think it's winnable in the court of public opinion. If Amber Heard winds up winning this thing, which won't happen for probably assuming she can appeal, which she still has to post the bond for, because she's not going to win now. I can't believe that Judge A will give her the time of day. For least reasons, it's like really not her ball game at this point. But if she appeals, if she can find the money to appeal, she won't win for like 2 years, 2 or 3. It's a long, the Court of Appeals is going to take a long time. And then bounce it up to the Supreme Court of Virginia, and they're going to take a long time. So I don't think we'll have a decision for quite a while. How sure are we on Elaine's case law? Not that sure. I'm just reading her by herself. So she might be wrong. She might be misreading the case law, although she did earn my respect by citing contrary authority. So I'm willing to give her a lot of respect. But, Johnny Depp may have better law. And if he does, I'll sure as hell tell you, because it'll be more what you want to hear anyway, so that'll be plus. And I'm happy to if that's what the law seems to require. So if they have better law on the proximate cause issue and they have better law on the defamation by implication issues, yeah, the rest of it's a loser, though. It's a complete loser on the jury didn't have enough evidence. It's a loser. It's a loser on they gave him the wrong dollar amount. It's a loser. It's a loser on what else did they have in there? Oh, the juror 15 issue. Oh, please, it's a loser. So it's his stuff. Okay, so you're saying that she has a winnable argument, yet she lied in the UK, Australia, and Virginia. How at this point is anything winnable for her because of the law? Whether she lied is not dispositive as to the legal question. That's how. I mean, whether or not she lied is a bad person. It certainly doesn't go to the issue of proximate cause. It doesn't go to the issue of whether defamation by implication is possible in Virginia, which are apparently novel questions. So, yeah. We'll see. 30 days to appeal. Yeah, that's going to run out, too. Yeah, so all she has left is the... how do some people still support Amber? I don't know. I don't know how people support her. Did I discuss her continuing to defame in public? No, I didn't really explicitly defame it. It wasn't part of the legal issues to be decided right now. I don't know whether or not she's technically defaming or not, but it's really annoying. Well, I'm going to sign off for now. I really appreciate the 1,972 likes. That's really nice of you guys. And I appreciate the $106 worth of super chat revenue. That's also very nice of you guys. And I do appreciate the 1,849 of you who are currently watching. That's also extremely nice of you guys. I do like to find coverage that you guys like to cover, and I'm glad that you found some value in it. And we'll definitely cover this more as we go on. we have a lot more stuff to cover. So I hope everything is great. I hope everyone else gets out there and enjoys their July 4th. That'll be awesome. I'm going to sign off for now, my friends. Don't forget to do the YouTubey things until later, my friends. Like, comment, subscribe. I hope all is well. Cheers, my friends, and goodbye.